I could not inform your lordship, my lord. My lord wanted to inquire whether there was a plan or not, my lord. I called the client, I sat with them. Lord, there are two premises that they built. Lord, both are Tika properties. One LBS applied for plan of both the properties. They had shown me two plans. Lord, I felt that one of the plans concerning this property may not be genuine. I told them to go and inquire. According to that, they built the construction. Lord, they inquired. It appears that there is no plan. That was a false plan given to them. They lodged an FIR also. Lord, this is the situation. Lord, Tika property, there is some protection. If my lord allows us a hearing, lord, we can apprise your lordship. My lord, this gentleman constructed on the strength of a plan. Lord, somebody has
Frauds being played upon the.
somebody has lord,
No,
lord
not somebody. They.
defrauded them.
No, no, no.
What a
Not
litigant will do,
defrauded.
lord.
Nobody should be
There is a
permitted
plan.
to.
I can show it. There's a, it requires a
Nobody
stamp.
should be permitted to bear the fruits of all these illegalities.
But not there is a plan.
Nobody should.
There is a stamp
Let it-
of the corporation. There is a
Let it
memo
come in
number
the due
given.
course.
There's a memo number given.
Chakravarti, let it come in the due course.
No, they are, lord, they are demolishing every day.
Let it be demolished.
At least
Anything
there
which
may
is not
not-
in accordance with law should
But
go away.
one more thing, under the 2001 Tika Controller Act, not the Bharatias, they have a right, the government, if there's an illegal construction, government can retain that. It need not be demolished. That is the only, I don't know whether anybody has placed it, that's the only provision under the Calcutta Corporation Act, a Tika tenancy, which protects an illegal construction. There's an immunity. My lord will kindly consider that. If my lord feels that there is no, based on the argument, my lord will dismiss it. At least let me move it. My lord, I only can beseech your lordship, my lord, I can only pray before my lord. At least give us a chance to apprise it. My lord then takes a call. At least, my lord,
Let it come in the due course.
Lord,
There
it will,
is
by
there
that
is
time the
nothing
building will
which
go.
claim damages if the building goes. If your building is constructed legally, you can claim.
We have already lodged an FIR against the LBS.
Very good.
To show our bona fide, my lord, we have already lodged an FIR.
Very good.
It's not that we are coming empty-handed.
Very
And lord,
good.
the
If you
Tika
have lodged
Tenancy
an
Act, my lord
FIR,
will
very
consider that. Tika Tenancy Act, that
Nobody goes to a dalal to get your sanction plan.
no, the LBS, he got another plan sanctioned.
Very good.
My lord will have a look at that. At least 5 minutes time. Give me one on a day. I know my lord has a very busy list. My lord, 5 minutes only.
Mr. Chakravarti, let it come in due course.
It has
You
come.
give
It
your
is not. It is not reaching. It has come.
Give your slip, we'll see.
Kindly, my lord.
Give your
I will not travel your lordship anymore. If my lord feels that
Give your slip.
I can not make, at least allow me to make 5 minutes argument, my lord. By the clock, 5 minutes.
See.
Lord, on restoration application, my lord.
My lord, may I permitted to
Why you are not appearing on the day?
My lord, this is my lord. Earlier, my lord, some mistake has happened on our part, my lord.
My lord,
Before your lordship's court, my lord. We were your lordship's court. We are regular, my lord. Grateful, my lord.
my lord, item number 1797 listed in the monthly list. Yes, yesterday also we have mentioned, and this is 5th time we are mentioning, but actually not taken up. Kindly
You
please,
can mention it 10 times more.
sir. Please, it is we have urgency.
Give your slip, we'll see that. We'll
May
consider
we
it.
permit to mention item number 2191 of your
1797.
lordship's monthly list, my lord. My lord, the petitioner is an widow lady. My lord, the private respondent, my lord, constructed unauthorized construction without leaving any space in between for her ingress and egress.
Give your slip, we'll see.
My lord, may I
Lord,
permitted to
kindly fix the matter any day, my lord.
Give your slip, we'll see.
My lord, may I permitted to mention item number 2006 of the monthly list, my lord, which is related to unauthorized construction, my lord. The petitioner is the buyer of a flat, but which is illegally constructed, and the court has already given an order of demolition, but they did not comply with the same and did not hand over the proper flat to the petitioner, my lord. This is my grievance.
Claim your right, seek damages. Give your slip.
My lord, subject to lifestyle leave, my lord, as mentioned in the
Yes.
the doctor, he was running his chamber from the tenanted property. Now, there was an agreement between the developer and the landlord and also the petitioner that the construction will be made and he will be given back the portion where he is running his chamber. Now, that his signature has been forged. The CID has said that yes, that is not his signature. Now, I have challenged this sanction plan. My portion has not been shown. Now, I have challenged the sanction plan before the municipal commissioner. He is not taking up the matter. So I was only beseeching your lordship. I cannot enter the premises. But it is difficult for me to run my chamber from another premises. I'm a doctor.
These disputed question of facts, whether your signature has been forged, not forged.
That is there in the CID's report. That I placed for lordship. I lodged a criminal complaint. The CID has come to a particular finding that this is not the signature is forged one. On the
Very
basis
good.
of that, I made an application before the commissioner under the section 397 for cancellation of sanction.
Give your slip, we'll
But
see that.
only any day lawsuit kindly takes up and directs the commissioner to dispose of liability. Any day subject to my kind.
Give your slip, we'll see.
Grateful to.
Call out the list.
I'm appearing for the municipal respondent.
But I'm for the petitioner.
Is that Tahirpur? No, this is different. This is WPA number 14362 of 2024, Sanichar Paswan versus State of West Bengal. In view of the clear stand taken by the respondent municipality, this court directs the respondent municipality to complete the process and release the pension and other retirement benefits to the petitioner within 4 weeks from the pronouncement of this order. If the respondent municipality failed to release the said amount within the said timeline, petitioner will be entitled for 6% interest on the outstanding retirement dues from 1/1/2024 till the actual date of payment. In the light of the foregoing discussion and observation, this writ petition is accordingly disposed of with a clear direction to the respondent authorities to ensure strict compliance with this order within the stipulated timeline. Non-compliance shall be viewed seriously and may invite further judicial consequences.
Great.
एक बार चेक कर लेना एक बार और।
I'm for the petition. Two, three.
This is the Tahirpur.
My lord, my lord.
There are 6 of them like this.
I'm for the notified area authority.
In view of the above discussion, this writ petition stands allowed. Respondent number 4 is directed to release the outstanding pension and other retirement dues of the petitioner within a period of 12 weeks from the date of pronouncement of this judgment. Respondent number 4 is further directed to ensure the regular and timely dispersal of monthly pension to the petitioner and all other similarly situated retired employees without further delay. With the aforesaid direction and observation, the present writ petition is allowed. There shall be no order as to cost.
May I pray for that interest, because they are not being paid for number of more than 3 years and 25 months, 36 months.
That's okay, sir.
Because I can pray before Lordship. Interest part is concerned. That's your Lordship.
Let them at least pay the money. Forget about the interest.
Grateful, my lord.
All these authorities have no money to pay.
Because we are the poor employee.
You take a shot. Yeah.
The poor thing.
एक मिनट So there are 6 petitions like this.
My lord. Similar petition.
Similar. 2 to 6. 2 to 7.
Yeah. It is super answer. इसको change करना These are all the same.
Same.
All the same.
चेम्बर में देना इसको साइन कर दूंगा सब all are the same. All six
Same.
petitions are the same. हाँ. So Tyrpur हो गया. All six are the same.
2 to 6, 2 to 7.
2 to 7.
Do you think it's sharp?
That is different. Eight.
8 times for the petition.
The writ petition is allowed and the following directions are issued. The director of local parties is directed to regularize the service of the petitioner in the same manner as done in writ petition 23748 of 2022 Alok Day, and to verify the service and pay particulars of the petitioner within a period of 2 weeks from the date of this order. Upon completion of such verification, the Director, Pension Provident Fund and Group Insurance shall ensure that the pension order shall issue the pension order within a period of 2 weeks. The respondent municipality shall thereafter release all pensionary and other retirement dues to the petitioner within a period of 2 weeks from the date of receipt of this PPO.
Grateful.
With the above direction, the writ petition stands allowed. There shall be no order as to cost.
Grateful. 3 matters are same.
3 matters are same. ये तो हाँ तीन हो गया. All 3 matters.
Yes. Obliged, my lord. Grateful.
11. Item 11. In view of the clear stand taken by the respondent municipality, this court directs the respondent municipality to complete the process and release the pension and other retirement benefits within 4 weeks from the pronouncement of this order. If the respondent municipality failed to release the said amount within the said timeline, petitioner will be entitled to 6% interest on the outstanding retirement dues from 1/9/24 till the actual date of payment. In the light of the foregoing discussion and observation, the writ petition is accordingly disposed of with a clear direction to the respondent authorities to ensure strict compliance with this order within the stipulated timeline. Non-compliance shall be viewed seriously and may invite further judicial consequences. बात पे साइन कर चेंबर सब साइन चेंबर में कर. List.
I have here for respondent number 5.
Listed for? What is it listed for? Non-prosecution. 12 for it, gets it listed.
No notice was also given.
So, see, that is the reason mentioning should not be allowed at all. Look at the mentioning slip is here. They mention it, matter gets listed, nobody comes. And at the time of mentioning, you should see the amount of pressure they put on the court. As if it's question of life and death. And when matters get listed, nobody appears. Every day I see this. Call the lawyer. Call the lawyer. Pass it over, call the lawyer.
Item number 14, madam, appearing for the petition in this matter. On last occasion, your lordship directed us to go before the civil court. Well, I have filed a small exception, madam, only pointing out that, madam, that if your lordship kindly, madam, accepts my exception to the report, madam. Well, only there is a contradictory statement in their order that I'll show, madam, and I'll take leave before your lordship, madam, so that I can go and file a suit. In the meantime, madam, at least 2 weeks injunction may be granted so that I can go and prefer a suit before the trial court. Only I'm paying this only, madam. I have instructions from my mail mailer that we'll take appropriate steps before the trial court. But exception may be recorded before your lordship, mailer. Otherwise, mailer.
Yes. The exception. Exception to the report filed by the corporation is taken on. Who appears for the Bidhan Nagar?
Mr. Nag was appearing for
Where's
this.
Mr. Nag? Where's Mr. Nag? You call Mr. Nag.
Very well. Well, let it be passed over.
Pass over.
My lord, in item number 15, I am for the petitioner, my lord.
Before my learned friend starts, my lord, kindly comes to page 7. He, my lord, says that there is an order passed by the Clinical Establishments Regulatory Commission. Kindly comes to page 7, annexure P3. But my lord, in his annexures, it is not there.
Page 7.
Page 7, my lord, it's a continuation of paragraph 13. He says a copy of the order passed by WBCRC is annexed herewith and marked as annexure P3. Now, my lord, from his index, it will appear that P3 should be between 29 to 31. But 29 to 31 is something else.
Yes, my lord, it is my inadvertent mistake. My lord, I have been appointed through legal aid. I have the copy of the order, my lord. If your lordship may permit, I may submit the order of the
Is this the way to handle matters from the legal aid?
No, my lord.
First put you on the legal aid. You should be depaneled from the legal aid if this is how you handle matters.
No, absolutely not. I tender my apology, my lord, for this. And somehow it has been missed by my clerk. Anyways, it is my fault.
Legal aid matters, sir. You should be more careful.
Yes, my lord.
These are people who are not able to afford clients, and that is the reason it is entrusted on you.
Absolutely, my lord. I bow down, my lord.
When you give your services to the legal aid, you should be more careful.
Yes, my lord.
How do you file these kind of petitions without even looking at the brief? You don't read it?
My lord,
why should you be in the legal aid panel?
My lord, I have prepared, but somehow my clerk has, I do not know whose mistake. Anyways, it is on me. It is on me.
So let the clerk come and argue the matters also now.
No, it is on
You should
me.
impale him.
No, it is on me, my lord. I truly apologize, my lord.
Withdraw it, file a better one.
So let that be.
My lord,
What is this matter?
My lord, this matter is, my lord, the petitioner is a disabled person, my lord. She is a disabled lady.
Should be more careful about these cases.
Yes,
Should be more humane towards these people.
it is my mistake, my lord.
And this is the manner you handle this matter.
No, my lord, may I file the order, my lord, if your lordship may permit.
The most important part of it is not there on record,
It is very unfortunate. I am so sorry, my lord.
on which you have come to the court. That is missing from the brief. She's a lady with special needs. She has come to the court because the
Absolutely,
proper services are not available.
absolutely, my lord. I bow down, my lord, before your lordship. এই যে, এই order। ফাইল করেছো, কিভাবে ফাইল করেছো? আপনাদের আগে অর্ডার যে নেই কিছু, আমার কাছেও নেই। আমি কপি করে দিই।
Take down the petitioner has referred the present writ petition seeking a direction upon the respondent authority to ensure the implementation of infrastructural
My lord, toilet, disabled friendly,
disabled friendly toilets, right?
toilet, my lord.
Infrastructural modification necessary to make their facilities accessible and disabled friendly. It is the case of the petitioner that she is a person with with disability and is wheelchair bound.
My lord,
Full stop. In the year 2018, she approached the facility of respondent number 3. Respondent number 3.
three, my lord.
Respondent number 3 for undergoing USG test.
Yes, whole abdomen.
At that time, she discovered that the said facility did not have disabled friendly washrooms. Full stop. The petitioner lodged complaints before various authorities in this regard. Full stop. The West Bengal Clinical Establishment Regulatory Commission, by its order dated 10/9/2020, directed the Calcutta Municipal Commissioner to inspect the facility of respondent number 3 and suggest modification by relaxing the applicable rules to the permissible extent, so as to provide a proper toilet for physically challenged persons. Full stop. Despite the said order, no action has been taken by the respondent authorities. Full stop. The petitioner has also raised grievances through the Sugamya Bharat application, inverted comma में डाल देना, Sugamya Bharat application, as well as before various other authorities. Full stop. However, till date, no action has been taken in this regard. Being aggrieved, the petitioner has preferred the present writ petition. Full stop. Petitioner states that he has inadvertently missed out the order passed by the West Bengal Clinical Establishment Regulatory Commission dated 10/9/2020 inadvertently missed out to annex the order dated so and so. Full stop. He states that though the same has been mentioned in the body of the writ petition at para 13, but the annexure mentioned at para 13 is not the order passed by the WBCERC, but is a different document. Full stop. He tenders unconditional apology for the said mistake. Full stop. He seeks and is granted liberty to file a supplementary affidavit, bringing on record the order passed by the WBSERC dated 10/9/2020. Full stop. Who appears for the respondents?
But I appear for the respondent number 3.
Lord, I appear on behalf of the Clinical Regulatory Commission. But the order has been passed at my instance that directing the authorities to renovate it in accordance with the.
You file your report.
I should.
The respondent.
I am the critical establishment.
Learned counsel for the respondent number 3.
3.
Respondent number 3 prays for and is granted 4 weeks time to file his affidavit in opposition. Full stop. Affidavit opposition, comma, reply if any to the same. Reply if any to the same within 2 weeks thereafter. List after 8 weeks.
Great.
I'm
grateful, my lord.
After vacation. We'll make it after vacation.
I'm grateful.
This will be 9th of September.
My lord.
My lord.
September.
Good.
Oh, sorry. 9th after vacation.
9th of November.
9th is 10th of November.
10th of
My grateful, my lord.
You file it.
My lord, I will file.
And legal aid matters, I'm telling you, be careful about legal aid matters.
My lord, I will file. I will file.
You should be more careful about these people who can't afford
Yes,
a lawyer.
Absolutely, my lord. It is.
And that is the reason we impanel you.
My lord. Absolutely.
Next. Yes, we'll take the password matter. Mr. Nag, where were you?
Sorry, I got stuck.
You should send your junior at least.
So sorry.
They are withdrawing this matter. Don't take any action for 10 days. All right, I'm not passing any orders, but just ensure that.
Yes.
Order passer.
वो line लिखवाया था ना that X is taken on record. Learned counsel for the petitioner seeks to withdraw the present writ petition to avail his remedies available in law. The present writ petition is dismissed as withdrawn.
Liberty to file a suit.
I'm not giving any liberty.
Yes.
Your liberty is available in law there.
Well, not to take any coercive action.
I have told him. No.
But for 10 days.
If I do that, you will take full advantage.
No, for 10 days, man. I'm only praying for
I'm
10
not.
days.
He's not taking any action.
Very
He has assured the court.
Very well. Mr. Nagis. Great. Well, this mail may be kept on record. The instruction.
एक उसमें line add कर दो. Learned counsel for the petitioner has handed over a copy of the instruction which he has received from his client to withdraw the present writ petition. The last paragraph. In view of the said, the present writ petition is dismissed as withdrawn. A copy of the instruction is kept on record.
Item number 13, my lord.
What number?
13. Why do you mention matters and then you don't appear in the court?
My lord, from the last 2 days, I am suffering from fever. That's why I'm not in the
Sir,
court.
you have come and mentioned the matter 2 days back. Why don't you join online?
was not in a position to join online. My junior is there. My lord, she may be late. She's coming within 15 minutes, my lord.
Yesterday also this matter was there. You guys mentioned the matter, all of you mentioned the matter, and then you choose not to appear in the court.
I am
All these matters are listed on your mentioning, and this is a regular phenomena. Every day, this court faces this problem.
It will not happen again, my lord.
If you're not interested, don't mention matters.
My lord, in this matter,
You are the advocate on record?
yes, my lord. Yes, my lord. Dev Kumar Chandra.
Learned counsel for the petitioner seeks to withdraw the present writ petition. The same is dismissed as withdrawn. Give your appearance.
Deeply obliged, my lord.
From next time, I will not allow any of your mentioning.
No, my lord, I bow down. It will not happen again, my lord. It's on a sleep.
I am for the petitioner. In this matter, my lord, on the last occasion, there was a direction upon the respondents to produce a report. Matter pertains to the pensionary benefits, release of the pensionary benefits.
Yes. Have you given a copy?
Municipality management report.
Have you given a copy to?
Even state was also directed to file a report, my lord.
Yes. Give the report.
They stated.
report.
The municipality.
Report in the form of affidavit filed by the state as well as respondent municipality is taken on record. Learned counsel for the petitioner seeks and is granted 2 weeks to file his exception to the reports filed by the state as well as the municipality. Let this matter be listed on September. Second September.
Grateful, my lord.
Yeah. Give your appearances.
সব ম্যাটারে নেই আমি ওই জন্য সব ম্যাটারে নেই আমি হ্যাঁ 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 হ্যাঁ
Well, item 17, well, I beg to appear on behalf of the petitioner.
Yes.
And this is a compassionate appointment I prayed for, and ultimately no result was come. Then I approached this honorable court in terms of
Bali municipality. Where is Mr. Banerjee? Ayan Banerjee.
Yes, Ayan Banerjee is appearing for the Bali municipality.
Where is he? Where is the
You
junior?
also see my room, room number 2. I did not find him.
The junior is generally here. She's also not here.
I shall inform my lord, Mr. Banerjee, let it be, my lord, taken
Tomorrow.
Anytime.
Tomorrow we'll take it.
Tomorrow or Passover, as your lordship think.
Yeah, I don't do Passovers, but tomorrow we'll have it.
Yes, no problem.
Not today, tomorrow. Keep it for tomorrow. Give back the. Well, generally they are there.
Yes, man. Oyanke bole do. Bollam to.
Yes.
I'm for the state lordship.
This is item number 18. I am appearing on behalf of the petitioner.
Well, I am the municipality.
Petitioner came before your lordship
Yes.
for pensionary benefit in respect of gratuity amount. Losses. Petitioners was appointed as a conservancy worker on 1st July 1981. Losses. Thereafter, he was retired on 31st August 2023 at the age of 60 years. Then the Assistant Director of Pension Provident Fund at Group Insurance issued pension payment order on 17th September 2024.
Yes.
Losses, kindly see page 14, pension payment order.
Yes,
PPO.
sir.
It was already approved. The gross gratuity amount 7,13,592, middle portion losses.
Yes.
But till today I have not received the said amount. Now I am a senior citizen at the age of 60. Therefore,
Well, I take instruction, my lord. Actually, position I have been taking is frankly, my lord. Municipality will disburse the amount, but no interest because it is not a profit motive business. It is only municipality.
At least give the principal.
Srirampur municipality.
Give the principal amount.
Well, after puja vacation, it will be. You give me some bidding time, my lord. Because your lordship knows very well administration of the state government and all. This is a municipal. No state government has been initiated fund. It is a municipal. It will be disposed of, my lord.
losses, kindly
Give me
visualize
bidding
that
time,
situation. If the amount,
Sir, whatever you get, take it.
He was
Not
employee
even
of our municipality. Now he have been coming.
the
all
entire
the-
amount is lying in the
municipality. You are.
All these municipalities are completely financially drained out.
Yeah,
But my lord, if the amount which I shall get after retirement, then I shall deposit in KVP in the post office. Now I am deprived for interest, and Supreme Court already specifically stated.
Then you go to Supreme Court.
No,
Best. Very good. Go to Supreme.
I bow down your losses.
I just said go.
Anyhow, I bow.
Your lordship knows very well. He has not been disbursed by the state government.
But losses within the specific time losses. Kindly give.
Hey, give me some breathing time, your lordship. I leave it at your lordship's pleasure.
At least
file your report.
But there is no. It will be disposed of.
So then I'll take your submission for it that you will release it in such and such time.
Such time.
How much time?
After 3 months.
3 months
most puja is some.
Puja সময় টাকা দরকার. It will
For
be there.
puja only he wants money.
Yes.
After puja, what will he do? He has to buy clothes. He has to buy sweets.
Yes. Before puja.
Everybody needs money before puja, sir, not after puja.
Lordship, I am not bargaining. I am bowed down to your lordship, please. My lord.
So you release the money to him. When will you release the money?
আরে পুজোর আগে না দিলে money is very much required before
And
puja.
where is your instruction? Get an instruction in writing. Tomorrow they will say we never told the lawyer to make this submission.
No.
Where is your instruction? Give me your instruction.
Then matter will be come up next giving the.
You give the instruction in writing that the corporation has asked that they will release the money.
Give me 1 week time. In the meantime.
Otherwise, tomorrow they will.
No,
tomorrow.
They will say I never told my lawyer.
No more tomorrow.
My lawyer be removed from the panel. He made a statement without any authority.
My lord. Your lordship is grateful. Deeply. My lord.
The petitioner has preferred the present writ petition being aggrieved by the inaction of the respondent. Which municipality is this?
Srirampur municipality.
Srirampur municipality.
Respondent Srirampur municipality in not releasing the gratuity amount, comma, even after 2 years of his retirement. Full stop. It is the case of the petitioner that he was an employee of the Srirampur municipality since 1/7/1981. Full stop. He retired from the services on 31/8/2023. Full stop. The respondent municipality issued PPO dated 17/9/2024. Full stop. He states that as per the said PPO, comma, the petitioner is entitled to the gratuity amount of rupees 713,592. 7,13,592. 592. And monthly pension at the rate of rupees 20,400. Full stop. It is the case of the petitioner that even though he's getting his monthly pension, comma, gratuity amount has not been released as yet. Full stop. He hence an amount of rupees 7,13,592 is still outstanding. Full stop. Petitioner states that he had made several representations before the respondent municipality, but the same have not been acted upon. Full stop. Learned counsel for the respondent municipality seeks and is granted 2 weeks to file his report by way of an affidavit. Full stop. Exception, if any, within 1 week thereafter, list after 3 weeks, list after 4 weeks.
Lordship, matter is to appear.
I'll tell you the date.
After 4 weeks.
4 weeks.
9th September.
Exception দিলে দেবেন or not?
And all conservancy workers have been regularized.
Well, fund is very poor. I know, my lord. Actual position is.
That doesn't
I
cut
know.
any ice with the court at all, sir.
correct
Then we have to get your properties auctioned and close down your municipality.
But is it same? Gratuity.
Say 19, my lord, I
Gratuity.
appearing on behalf of the state, my lord.
Just change the dates. What are the difference in the dates?
Lordship, here, my lord, the actual employee has been died. Now his wife has been applied.
And
died in 1918.
gratuity amount
Died in
is
2025.
Lordship, kindly see
After
PPO.
7 years.
Just,
Page
just
15.
a minute.
আমাকে বলতে দিন page 15 lordship.
Page 50.
Page 15. Gratuity amount 7,30,000.
This is wife as
Yes, he is suffering, my lord,
Take
heart
on.
disease.
The petitioner has preferred the present writ petition, being agreed by the inaction of the respondent, Sirapur municipality, in not releasing the gratuity amount, comma, even after 7 years of her husband's death. Full stop. It is the case of the petitioner that her husband was a permanent employee of the respondent municipality. Full stop. He expired on 31/7.
31st/7,
31st
2018.
18.
The respondent issued the PPO on 25/11
November
2022. Full stop. He states that as per the said PPO, comma, the petitioner is entitled for a total gratuity amount of rupees 7,30,000.
30,000.
7,30,000.
And monthly 7,30,000. 30,000. And the monthly pension of rupees. What is the monthly pension?
Monthly pension, my lord, at present 10,530.
वो छोड़ दो. He states that he's getting she states that she's getting the monthly pension
17,550.
but
17,000.
gratuity amount has still not been released in her favor. Full stop. Learned counsel for the respondent municipality seeks and is granted 2 weeks time to file his report by way of an affidavit. Reply to the same, if any, within 1 week thereafter. List same day.
Same day.
9th.
Affidavit of service is taken on record.
একই দিনে থাক।
Grateful. Give me your best.
Grateful.
18.
Affidavit service may be kept on record.
I'm appealing for the state of West Bengal.
Item number 20, my lord, I am praying for not this week.
Not?
I am praying for not this week, my lord. Mr. HON'BLE is appearing in this matter. He has some personal difficulty.
Not this week.
But I'm led by Mr. Anju Chatterjee, a senior advocate, my lord. Next week, my lord, probably he will be having some difficulty, my lord, for some his personal difficulty, my lord. Next week, my lord, will be some difficulty. Next week, my lord, we take it up, my lord.
Then, my lord, Thursday.
And let this matter come on the 9th of September. 9th September. At the request of the parties, let this matter be listed on 9th September.
Any.
Grateful.
Grateful.
Oh. Ninth. At the request of the parties, let this matter be listed on 9th September.
I am for the petitioner. I am appearing to Mr. Doctor. The petitioner is an ex-employee of Calcutta University. He was first appointed in the year 1985 and continuously he served up to January 2022.
January?
22, or when he retired on attaining the age of superannuation. But still, he has not been paid full pension. He is being paid his pension on ad hoc basis at the rate of 8,800 and a gratuity amount of 2 lakhs only has been paid to him till now. But Lordship, kindly see the letter of the chairman that is at page 24. The chairman is writing to the director of pension, provident fund and gratuity to all formalities have been fulfilled and then my lord, kindly see for a moment page 41. Here the chairman has indicated the amount the proposed pension is 17,600. Proposed gratuity 5 lakhs 80,000 and 8,800. And my lord, previously I came before this order. And the order of justice Kaushik Chandra is at page 103. There the municipality submitted in January 2025.
Page number?
Page number, my lord, 103.
Yes.
That gratuity has been paid, that they submitted in January 2025. But my lord, now they are submitting that the gratuity is about 5 lakhs 8,800. And after the order passed by Justice Kaushik Chandra, Honorable Mr. J. Chandra, only 12,000 rupees have been given in my pension account. And I am paying my lord, let them file affidavit.
Yes.
Gratuity has already been paid, my lord. But my lord, his contention is that his pension should be calculated from the date of the initial engagement as a casual employee, my lord. That is not comes under purview of the municipality. On that point, my lord, the DLB can submit, my lord. I have sent proposal and his service was regularized in the year 2010, my lord, on 1st January 2010, and he was retired on 31st January 2022, my lord. That is, my lord, the page 63 is the date of appointment in a sanctioned vacant post, my lord. That is 1st January 2010, my lord. He demands that paid for notional benefit in case of pensionary from the 1985 when there is no sanctioned vacant post and he was engaged as a casual employee, my lord.
So your gratuity has been paid, the entire gratuity.
No, my lord, no. Only 2 lakhs have been paid.
No, my lord. My instruction is
No. Only 2 lakhs.
all retired benefit has already been paid, my lord.
No, my lord. Retired benefits only on ad hoc pension to the extent of 8,800. And gratuity amounting rupees 2 lakhs have been paid and nothing more. And this is also evident from the letter of the chairman, that is at page 41. Page 41 of the chairman.
Page 40.
He is writing proposed gratuity is 5,80,800.
Page 45 is
41. And he is writing proposed pension is 17,600.
Page?
That is,
page 41
page
is
41.
41 is the service book, my lord.
Not the service book. Office of the Councillor, Contact Municipality. Form for pension and gratuity.
File your reports. This is the petitioner.
According to the my lord.
File your report, sir. You have to file your report. These are.
May I submit one thing, my lord? My lord, from the payment of the gratuity, my lord, I can submit report, my lord. But the contents and prayer of the
No, but state will file. You are appearing for the state. The state will file as far as the PPO is concerned.
on the basis of the
the documents have already been sent by the Contai municipality.
Yes, my lord. I have already sent the proposal and he
take a
is not
decision.
my lord. He is demanding that he will get pension from the 1985.
He can't.
I am ready to, and the DLB is also ready to disburse the pension from the calculating from the date of 2010.
Yes, from the date when he has been regularized.
2010, my lord.
From the date.
But he demanding the notional benefit from the 1985.
Yes, my lord.
How do you get it from 1985, sir?
Yes. Because, my lord,
the law is very clear to that extent. From your date of initial appointment, anyway, you file your report. I don't need to get into that. The petitioner has preferred the presented petition, being agreed by the inaction of the respondent in not issuing the Provident Fund order and not releasing the pension and other retirement benefits, even after 3 years of his retirement. Full stop. It is the case of the petitioner that he had joined the service of the respondent municipality by appointment letter dated 31/8/1985. Full stop. As a casual worker.
Casual worker.
As a casual worker. Full stop. Later, he was regularized in the year.
In the year 2010, 1st January 2010.
1st January
page
2000.
63, my lord.
Page 60.
In a sanctioned vacant post.
Page
63.
The 6th column, my lord, page 63, my lord. 1st January 2010.
Date of appointment, my lord.
Date of appointment, my lord.
It was underlined, my lord.
6th column.
Underline and double tick mark.
Clarify. On 1/1/2010. On the post of clerk, right?
Yes.
On the post of clerk.
Prior to that.
On the permanent post of the clerk.
Yes.
On the
Permanent is the
post of
second
the
column,
clerk.
my lord.
Full stop.
Prior to that, he worked as Group D employee.
He states that he retired on 31/1/2022. Full stop. even after his retirement, comma, no PPO has been issued in his favor, full stop. He petitioner further states that he has been receiving ad hoc pension and has received gratuity amount of rupees, ad hoc gratuity amount of rupees 2 lakhs. Full stop. He further states that despite various representation, comma, no steps have been taken to issue the PPO and to further release the pensionary dues and gratuity amount in his favor. Full stop. Learned counsel for the respondent, municipality as well as state seeks and is granted 2 weeks time to file report by way of an affidavit. A reply to the same, if any, within 2 weeks thereafter. List after 6 weeks. Give it after vacation के बाद 12th November.
My lord, till now no people has been issued to me for long years of my service. This is my prayer, my lord.
So I have recorded your prayer.
Yes, my lord. I am obliged to.
तो 10th कर दो 10th November. 10th November.
Deeply obliged.
We can wait. Yes.
My lord, I am appearing for the petitioner.
My lord, I am appearing on behalf of the state of West Bengal.
Same Contai?
Yes,
Yes, my lord.
This is
Yes,
Contai,
this
my
is
lord.
also Contai.
Yes.
Out of the 7,30,000 gratuity amount, my lord, 4,15,000 has already been paid, my lord.
How much?
4,15,000 has already been paid, my lord. 3,15,000 is due.
My lord, may I be permitted
Yes,
to?
yes, sir, please. Yes.
My lord, the petitioner was Group D employee clerk, retired on 31st 10/2020.
31st?
Have been looked by
Sir, on 31st?
31st October 2020. 31st October 2020.
Yes.
My lord, kindly have a look page 3, para 2B of this writ petition. Para 2B.
Yes.
The authority concerned settled the pension amount 25,150 from 1st November 2020. My lord, kindly have a look page 20, annexer P4, revised PPO. Page 20.
Yes. Yes.
Details given there. According to PPO, the petitioners will get the arrear pension 12,98,112. My lord, calculation given page 5, para 2I. Page 5, para 2I. The authority concerned paid 9,52,184 on different consecutive dates. My lord, thereby the due pension was 3,45,928. Kindly have a look, page 5, para 2J and K. Para 2J and K. After filing this petition, my lord, the authority concerned paid 1,30,000 on 25th June 2025. Thereby, my lord, the due pension 2,15,928 till now. My lord, kindly have a look, page 5, para 2H. Now, the question that is the gratuity portion, my lord. sorry, that is the gratuity portion. The total pension, arrear pension 3,45,928. Now, they paid 1,30,000. So, 2,15,928 due. And that gratuity, my lord, they paid only 50,000. Now due gratuity 3,15,000. 3,15,000. So, my lord, I have given the details in my prayer. The prayer portion 10A. 10A, page.
Prayer start for page 10.
Page 10, my lord. My lord, the arrear pension now due 1,30,000 and the gratuity amount now till due 3,15,000 till date. Kindly, my lord, this amount may be paid
So
with
gratuity
12% interest.
arrears is how much is due now?
Arrear pension due 1,30,000 and gratuity amount due 3,15,000.
পরে বলতে in the meantime after filing. Minus.
And my lord, I am paying before your lordship with 12% interest. The continent representation given.
Take down.
My lord, I am disputing the fact, my lord. Arrear pension has already been paid, my lord. Only the gratuity amount is due 3,15,000.
File your report.
Already given the details, my calculation given.
The petitioner has preferred the presented petition being aggrieved by the inaction of the respondent, quanti municipality, as well as the state in not releasing the arrears of gratuity and pension, even after 5 years of his retirement. Learned counsel for the petitioner states that he was an employee of the respondent municipality, full stop. He retired from the services on 31/10/2020, full stop. He further states that he has received part payments towards the pension and gratuity, and as on today, there is an outstanding amount of rupees 1,30,000 towards arrears of pension and rupees 3,15,000 towards gratuity, full stop. He further states that the respondent municipality had paid he further states that at the time when the petitioner had preferred the presented petition, the arrears of pension which were due was rupees 3,45,928 and the gratuity amount due was 3,65,000. Full stop. Though in the interregnum, some payments have been released, and as on date, the petitioner seeks rupees 1,30,000 as arrears of pension and rupees 3,15,000 as gratuity amount due to the petitioner. Full stop. Learned counsel for the petitioner further states that he had made several representations to the respondent quanti municipality, but the same have not been acted upon. Full stop. Learned counsel for the respondent quanti municipality disputes the stand of the petitioner and states that there is no arrear of pension due to the petitioner and that only the gratuity amount is is due, full stop. He seeks and is granted 3 weeks time to file his report by way of an affidavit, bringing on record the payments which have been released to the petitioner and the amounts which are due to the petitioner for his arrears of salary as well as gratuity. Full stop. Learned counsel for the state also seeks and is granted 3 weeks time to file his report by way of an affidavit. Reply to the same if any within 2 weeks. ऊपर भी लिख देना reply if any within 2 weeks thereafter. List after same date then. Affidavit service taken. 10th November.
10 November.
Their retired employees were suffering from old age disease.
Should I give you December?
My lord, I am appearing for
23, my lord, same matter, my lord. Matter, my lord,
It-
7 lakh.
matter is relating to the area pension gratuity of the retired employees, my lord.
Same, my lord, I am referring the.
The petitioner was a Group D employee, that is clerk, and retired on 28 February 2022. Kindly have a look, my lord, page 4, para 2B. Page 4, para 2B. And then the authority concerned settled the pension, my lord, amount 25,900 from the 1st November 2022. Kindly have a look, my lord, page 19, annexer P3. Page 19, annexer P3. And details given there in the PPO. My lord, according to the PPO, the petitioner will get the area pension 7,52,686 from March 2022 to May 2024, that is for 27th March. Kindly have a look, my lord, page 4, para 2E. Page 4, para 2E. Details calculation given there. The authority concerned paid the provisional pension at the rate 7,400 per month, and for the period 3rd January 2024 to 21st January June 2024, having the total amount 51,800, and thereafter the authority concerned paid 3,75,000. Thereby due pension was 3,25,886. My lord, after filing this petition, the authority concerned released the area pension on 25th June 2025, 1,63,000. So, my lord, the due pension amount till date 1,62,886.
1 lakh?
1,62,886. Kindly have a look, page 4, para 2G. Para 2G. My lord, the full gratuity amount 7,30,000. The authority concerned paid first 1,50,000 on different consecutive dates. Now the due amount gratuity was 5,80,000. And after filing this petition, my lord, they paid on 13/6/2025, or 13 June 2025, 50,000. So the due amount now gratuity 5,30,000 till date. My lord, details given in page 10 para 10b. Page 10 para 10b.
Well, I'm admitting this. 5,30,000 is due for the gratuity. I'm admitting this. No need to submit any calculations.
Para 10b, my lord. I am now praying before your lordship to release the area pension and gratuity with interest at the rate of 12%.
Arrears you have paid?
My lord, 5,30,000 is due, my lord.
For gratuity.
I'm disputing the arrear pension. Arrear pension has already been disbursed, my lord. It was credited to the account, my lord.
All right. You take down. The petitioner has preferred the presented petition being aggrieved by the inaction of the respondent municipality in not releasing the arrears of gratuity and pension amount, comma, even after 5 years of his retirement. Full stop. It is the case of the petitioner that he was an employee of the respondent municipality. Full stop. He retired from the services on 28/2/2022. Full stop. The respondent municipality issued PPO dated 5/7/2024. Full stop. As per the said PPO, comma, the monthly pension has been fixed at rupees 25,900 and gratuity amount of rupees 7,30,000. Full stop. The petitioner states that as of today, he is entitled to receive arrears of pension of rupees 1,62,886 and gratuity amount of rupees 5,30,000. Full stop. He admits that partial payments have been released on account of arrears of pension and gratuity. Full stop. Learned counsel for the respondent states that the arrears of pension have already been paid and admits that the gratuity amount of rupees 5,30,000 is yet to be paid. Full stop. Though he seeks and is granted 3 weeks time to file his report by way of an affidavit, bringing on record the pension amount, arrears of pension which have already been paid, and if any amount is due to the petitioner. Full stop. The report shall also indicate the amounts which have been paid towards gratuity and the remaining gratuity which needs to be paid to the petitioner. Full stop. Seeks and is granted further time of 2 weeks, 3 weeks. Full stop. Learned counsel for the petitioner. इसके बाद लिखते हैं. Learned counsel for the petitioner seeks 2 weeks to file his exception to the said report. Let this matter be listed. Same. Affidavit of service taken.
Grateful, my lord.
I am appealing for the state Kolkata Municipal Corporation.
My petition, my lord. In this petition, I am seeking my prayer before my lord is for them to consider my representation with regard to mutation. May I, my lord, give a short history with respect to the matter?
History, then I'll come back.
It'll take 30 seconds. Milord.
History, the word you
Very
use
small
history.
history, Milord.
They are asking for
Come back in
declassification.
5 minutes.
Lord, may I?
Now I can hear your history.
Lord, the
Worship,
situation.
before my learned friend starts, he's asking for the declassification of the scheduled property from Tika, and he has not met the Tika party.
It's not a Tika property to begin with.
He has written in his representation
Lord,
that
may I
it is
just
a
place
Tika
the
property.
facts? I will deal with my learned senior friend's issue on maintainability with the facts itself. Lord, just a small history with respect to the property. The property was originally in the name of one individual by the name of Hemalini Devi. She passed away, my lord, sometime on 31st May 1961. I'm sorry, she sold the property to the mother of the petitioners on 31st May 1961. Thereafter, my lord, the mother of the petitioners passed away on 21st of September 1998. Lord, I have also annexed the death certificate at page 33. Pursuant to the death of the mother of the petitioners, she had a will, the mother. Such will was duly probated, and in terms thereof, the property was jointly made over to the petitioners before this honorable court. The petitioners thereafter, my lord, since grant of probate is not perfection of title, my lord, attempted to go to the municipal authorities to have their names mutated. And on approach of the municipal authorities, they come to learn orally, albeit, my lord, that the property is purportedly marked as Tika in the municipal authorities' books. Then, my lord, being now they then approach their lawyers. Their lawyers advise them to file an application under the Right to Information Act to figure out whether the property is actually marked as Tika or not. Why, my lord, I say this is that prior to this oral information, at all given occasions, the petitioners were giving municipal taxes, wherein no intimation was given whether the property was Tika or not. They issue an RTI, my lord, suspecting erroneous flagging of a Tika property. My RTI application, my lord, is at page 56. If my lord kindly takes that page. Annexed as, my lord, annexure P7. My simple questions in the RTI application are that whether the premises number so-and-so being so-and-so is Tika or not. Whether there is any challan or return filed in the above premises. Now, my lord, if there is a challan or return in form A filed in the above premises, I am non-suited. My question of whether it is Tika or not goes for a toss, my lord. I then receive a reply, my lord, at page 58, dated 21st of December 2024. If my lord will kindly take it. In this, may I place, it's a one paragraph reply. In reply to my application under the RTI Act, in this connection to the above noted subject, this is to inform that on verification of the presently available office records, it appears that no returns in Form A, specifically in respect of the premises noted above, is found to be submitted within the stipulated period, and no question of determination of the same as so far arises. So the aspersion casted that the property was a Tika property is absolved by this reply. And this, my lord, is a reply by the Narkeldanga Regional Tika Tenancy Office. So in furtherance thereto, my lord, I annex these two documents and I write to the municipal authorities. My letters, my lord, are at page 59. For grant of mutation, I reiterate the entire facts that forms a part of the writ petition, and I request the respondent authorities, my lord, if my lord kindly takes the next page. Finding no other alternative, my lord, the second but last paragraph.
Yes.
To grant mutation in our favor. I once again write on the 22nd of April, no response. And that is why I am before my lord, and that is why my prayer stands that I am not seeking for the Tika officer to declassify the property. They have already given me a go-ahead. I am asking them to declassify my property as a Tika from their records. They are not the appropriate authority to do the same. They are merely not granting me mutation on such ground. My humble request before my lord is kindly directs them to issue, to hear out my representations and grant mutation in my favor. On hearing out my representation.
RTI response,
yes, my lord,
will not be factually something proving in favor of you. Make the Tika controller a party to this.
And the question was twofold. First, whether the property is Tika or not. Second, whether any return has been filed. The reply is only respect of the second part.
Yes.
Let them take the determination that it is not a Tika property under the Tika Tenancy Act, Or either they make a party Tika here.
Make them a party.
I shall make. My lord, kindly grants me that leave. I shall make and serve them another copy. My lord, prior to such, my lord, may I
Who
just
should be
file
a
my-
party? Tika
Tika controller, my lord.
Tika control.
According to my learned senior friends, as the point. If my lord they grant a certificate that I'm not
Learned-
Tika property, I'm true.
They will never do that unless
I'm hoping so, my lord.
learned counsel for the petitioner seeks and is granted liberty to add Tika controller, a party respondent to the present writ petition. Full stop. Necessary steps. Learned counsel for the petitioner states that he shall take necessary steps to add the Tika controller, a party respondent to the present writ petition. Full stop. वहां जहाँ लिखा हुआ ना seeks how much time?
2 weeks.
2 weeks कर देना
1 week. Perfect. My lord, can grant me 1
He
week.
seeks 2 weeks time to take necessary steps.
And may I
List after
1 week add kore serve kore affidavit of
list
service
after 3
का-
weeks. Second.
Lordship,
You serve them and come back 2nd September.
My lord, may I till such time file my affidavit of service with respect to the respondents?
File it.
Composite affidavit of service.
My lord, my lord, in respect to item number 23, I was appearing for state. My lord, by the time I was coming, the matter all these matters are group matters. These are petty matters pending before Supreme Court. My lord, by the time I have come, my lord, these matters have been called randomly. My lord, I have missed
Randomly?
being able to appear at the time. When it
All
was-
matters have been called out one by one. Every
I
matter
was
has
coming
been
all
order
the way
passed.
from that 750. I mean,
Which
6
matter you are appearing?
item number 23, Your Lordship.
Give your appearance. There is a direction to pass an file a report by way of an affidavit. Do that. Take
Grateful,
his
grateful.
appearance in 23.
Grateful, Your Lordship. Extremely grateful.
My lord,
Yes.
item number 25 to 36, my lord, I'm appearing on behalf of the petitioners, my lord.
Yes.
My lord, the petitioners are the retired employee of Bardwan municipality, my lord. After retirement, they are receiving only the pension, my lord. The gratuity and the arrear pension is still due, my lord. My lord, kindly remember, my lord, the similar order has been passed by your lordship of Bardwan municipality, my lord, of Goitubati municipality, my lord. If your lordship kindly allow me, I can.
You are appearing for this.
My lord, I will file a report, my lord. Kindly allow me 3 years time, my lord. I shall file a report.
You want to file a report? Take down. The petitioner has preferred the present writ petition, being aggrieved by the inaction of the respondent municipality in not releasing the arrears of pension also, right?
Arrear pension.
Arrears of
Gratuity and arrear pension.
arrears of pension and gratuity amount. And you have retired?
My lord,
Comma, even after 6 years of retirement.
2019, my lord.
6 years of retirement. Even after 6 years of retirement. It is the case of the petitioner that this is wife has come, right? Sita.
Yes, my lord.
Even
The
after
wife.
6 years of her deceased husband's retirement. It is the case of the petitioner that her deceased husband was an employee of the respondent municipality. Full stop. He retired from the services on 1/6/2019. And expired on the same day.
Same date, after date of retirement.
And expired on the same day. Full stop. After his expiry, the respondent municipality issued PPO dated 1/11/23. Full stop. As per the said PPO, comma, the petitioner is entitled for a gratuity amount of rupees 7,30,000, comma, enhanced pension of rupees 17,050 from 1/6/2020 to 10/6/2024, comma, and family pension of rupees 10 lakhs 230. No, 10,230, sorry, not 10 lakhs. 10,230.
Actually, my lord, I have submitted report, my lord, then there, some person, my lord, has already been taken the part payment, my lord.
Whatever you have to file, you file it. This is what is there in the petition. 10 lakhs 230 from 11/6/2024. 10 lakhs 230 from 11/6/2024. ये पेज इस पे मिल जाएगा. Page 14. चेक कर लेना एक बार अमाउंट्स. Page 14. Full stop. It is a case of the petitioner that even though she is getting the monthly pension, comma, the gratuity and arrears of pension has not been released till date. Full stop. Learned counsel for the petitioner. What is that judgment which you gave me? Is the same municipality, different one?
No, they were different.
Koidobati municipality.
Okay. Learned counsel for the respondent seeks and is granted. How much time? Mister, how much time?
3 weeks time.
3 weeks time to file his report by way of an affidavit. A reply, if any, to the same within 2 weeks thereafter. List after. This will go after vacation only then.
My lord, affidavit of service be kept on record.
Affidavit of service is taken on record. Give a date. 11th November. 10th November. 10th November.
November. My lord, item number 26, my lord, similar. My lord, she is the employee, my lord. Here she is the employee.
Mala Nandi. Take down. The petitioner has preferred the present writ petition being aggrieved by the inaction of the respondent municipality in not releasing her pension, arrears of pension and gratuity amount,
2024.
comma, even after. When did she retire?
2024, my lord. 31st October 2024.
नहीं बस even after mat karna, full stop. It is the case of the petitioner that she was an employee of the respondent municipality, full stop. She retired from the services on 31/1/2024. She also expired on the same day.
No.
Then, nahin?
She is the employee, my lord.
She's still alive, right?
She's
Full stop. Retired on so and so day. Even after PPO, when was the PPO issued?
PPO 20.
Further submits that the PPO was issued on 20th January 2025 as per the said PPO. How much is the recovery
6,90,982
towards pension or gratuity?
gratuity and arrear pension, my lord.
pension amount is 18,000, gratuity is 6,69,000. Net retiring gratuity is so and so. Where's the arrears of pension? As क्या लिखा है? हाँ. Her pension was fixed at rupees 18,650, full stop. She states that gross gratuity of rupees 6,69,722 according to the said PPO issued by the Director of Pension Provident Fund and Group Insurance has still not been released in her favor, full stop. She's learned counsel for the petitioner states that they have made several representations to the respondent municipality, but the same have not been acted upon, full stop. Learned counsel for the respondent seeks and is granted 3 weeks time to file his report by way of an affidavit. Reply to the same, if any, within 2 weeks thereafter. List on 10th.
Where affidavit of service?
Affidavit of service taken out.
Kept on.
Now 27.
27, my lord, is similar to item number 25, my lord.
This is
my
the wife.
Yes, my lord.
The petitioner has preferred the present writ petition being agreed by the inaction of the respondent municipality in not releasing the gratuity and arrears of pension amount, comma, even after, when did he die? Even after
2nd May 2008.
7 years of 7 years of the deceased husband's death.
On the same date.
When did he die? Same day. What do you do? Same day retirement, same day death. Full stop. It is the case of the petitioner that her deceased husband was an employee of the respondent municipality. Full stop. He retired from the services on 2/5/2018 and expired on the same date. Expired on the same date. Full stop. Even after the expiry of the petitioner's husband, comma, after the expiry of her husband, of her husband, comma, the respondent municipality issued PPO. When did they issue the PPO?
10th September 2020.
PPO dated 10th September 2020, full stop. As per the said PPO, comma, the petitioner is entitled to an amount of rupees
2,83,314.
Where do you get that?
My lord?
2,57,040. Gross death gratuity.
Total, my lord, 2,83,314. 2,57,040. My lord, kindly see my calculation sheet, my lord, page number 15, my lord.
Where's the amount here? Anyway, क्या लिखा है? That to a gross death gratuity of rupees 25 lakhs 7,040. Full stop. It is a case of the petitioner that even though she is getting her monthly pension, comma, gratuity amount and arrears of pension has not been released yet. Full stop. Hence, she states that an amount of rupees 2,83,300 314 is outstanding. Full stop. Petitioner further states that various representations have been made to the respondent before the respondent municipality, but the same have not been acted upon. Full stop. Learned counsel for the respondent seeks and is granted 3 weeks time to file his report by way of an affidavit. Reply to the same, if any, within 2 weeks thereafter. List on same.
Affidavit of service.
Affidavit of service is taken on record.
My lord, same matter, my lord. The husband has died and she's the wife. Similar to item number 25, my lord.
The petitioner has preferred the present writ petition, being agreed by the inaction of the respondent municipality not releasing the gratuity amount and arrears of pension even after he died on
31st May.
31st May 2019.
even after
My lord, pardon me, my lord, 13th June 2021.
even after 4 years of the petitioner's husband, even after 4 years of the passing away of the petitioner's husband, who was an employee of the respondent municipality. Full stop. It is the case of the petitioner that her deceased husband was an employee of the respondent municipality. He retired from the service on 31/5/2019 and expired on
13/6/2021.
Full stop. During the lifetime of the petitioner's deceased husband, the PPO was not issued. Full stop. After his expiry, the respondent municipality issued PPO dated 28/2/2024.
24.
Full stop. As per the said PPO, the petitioner is entitled for a total gratuity amount of rupees
6,15,450.
450, enhanced pension of rupees 18,650 from 1/1/2020 to 13/6/2021, and family pension of rupees 11,190 from 28/5/2024. Full stop. 11,190 from 28/5/2024. Page 14 now. Full stop. It is the case of the petitioner, though, that even though she is getting her monthly pension, gratuity amount and arrears of pension has not been released. Hence, an amount of rupees 12,92,000
12,92,964
is still outstanding. Full stop. Petitioner states that she had made several representations, but the same have not been answered. Full stop. Learned counsel for the respondent municipality seeks and is granted. Anybody state is not a party? Only municipality. Seeks and is granted 3 weeks time to file his reply by way of an affidavit.
The affidavit of service be kept.
Reply to the same, if any, within report by way of an affidavit. Reply to the same, if any, within 3 weeks. Within 2 weeks thereafter. List on same date. Affidavit of service taken on record.
My lord, the petitioner is still alive, my lord.
The petitioner himself,
Petitioner himself.
The petitioner has preferred the present writ petition, being agreed by the inaction of the respondent municipality in not releasing the gratuity amount and arrears of pension. Full stop. It is the case of the petitioner that he was an employee of the respondent municipality. Full stop. He retired from the services on 31/3/2024.
2024. 31st March 2024. Retired.
And
He's
still alive.
He's still alive, man.
Full stop. The PPO was issued on
12th September 2024.
Petitioner further states that the PPO was issued on 12 September 2024. As per the said PPO, the petitioner is entitled to gratuity amount of rupees 7,18,740. 740. And and 19,800
Pension.
towards pension, right?
Pension.
Towards pension. Full stop. It is a case of the petitioner that even though she is getting her monthly pension, gratuity amount and arrears of pension has not been have not been released till date. Full stop. Hence, an amount of rupees 7,75,117 is outstanding. Full stop. Petitioner states that he had made several representations for the release of the said amount, however, nothing has been released yet. Full stop. Learned counsel for the respondent seeks and is granted 3 weeks time to file his report by way of an affidavit. Can reply to the same, if any, within 2 weeks thereafter. List on so and so. Affidavit of service is taken on record. How many matters?
12. Petitioner is still alive, my lord.
The petitioner has preferred the present writ petition, being agreed by the inaction of the respondent municipality in not releasing the arrears of pension and gratuity amount to the petitioner. Full stop. It is the case of the petitioner that he was an employee of the respondent municipality. Full stop. He retired from the services on 31
January 2021.
31st January 2021. Full stop. The respondent municipality issued PPO dated 30th
June
2022. Full stop. As per the said PPO, the petitioner is entitled to a total gratuity amount of rupees 7,30,000. 7,30,000, pension of rupees 21,750. Full stop. It is a case of the petitioner that even though he's getting Samir Chandradas, right? He's getting his monthly pension, gratuity amount and arrears of pension has still not been released. Hence, an amount of rupees 7,07,246 is outstanding. Petitioner states that he had made several representations for the release of the said amount, however, nothing has been released yet. Learned counsel for the respondent seeks and is granted 3 weeks time to file his report by way of an affidavit. Reply to the same, if any, within 2 weeks thereafter. List on such and such date. affidavit of service is taken on record. You should have given a brief with all the dates and all. It would have made my life easy. The petitioner has preferred the presented petition being agreed by the inaction of the respondent municipality not releasing the gratuity amount and arrears of pension, full stop. It is the case of the petitioner that it's the petitioner only, right?
Petitioner.
That he was an employee of the respondent municipality, full stop. He retired from service on 29/2/2020. The respondent municipality issued PPO
22nd October.
on 22nd October 2024. As per the said PPO, the petitioner is entitled to a gratuity amount of rupees 5,79,150 and pension amount of rupees 17,550. Full stop. Learned counsel petitioner states that though the petitioner is getting the monthly pension, gratuity amount and arrears of pension is still pending. Full stop. Hence, an amount of rupees 7,07,246 is outstanding. Full stop. Petitioner further states that various representations have been made for release of the said amount, however, nothing has been released.
Outstanding amount 2,77,947.
Oh, 2,77,000. Oh, sorry, 2,77,947 is still pending.
May I leave, my lord? May I leave, my lord? Matter is running, my lord.
Just give your appearance in all the matters. 31. Then same line. Learned counsel for the respondent seeks and is granted 3 weeks time to file his report by way of affidavit, reply if any within 2 weeks thereafter, list after so and so, affidavit of service is taken on record. All right. Similar matters, just give a brief. It would have just made it easier. We could have just given the affidavit of service taken on record. Full stop. The petitioner has preferred the presented petition being agreed by the inaction of the respondent in not releasing the gratuity amount and arrears of pension. Full stop. It is the case of the petitioner that he was an employee of the respondent municipality. Full stop. He retired from service on
31st January 2023.
31st January 2023. Full stop. The respondent municipality issued PPO dated
25th July 2024.
2024. Full stop. As per the said PPO, the petitioner is entitled for a total gross retiring gratuity of rupees 3,75,023 and pension amount of rupees 16,550. Full stop. It is the case of the petitioner that though he is getting his monthly pension, gratuity amount and arrears of pension has not yet been released. Full stop. Hence, an amount of rupees
5,07,864.
5,07,864 is still outstanding. Full stop. Learned counsel for the petitioner further submits that various representations have been made before the respondent authority, however, no amount has been released as of yet. Same then. Learned counsel for the respondent seeks and is granted so and so, so and so. Is a petition only, right? इसमें बाकी same रहना. When did he retire?
30th April 2020.
30th April 2020. PPO was issued
19th November 2021.
19th November so and so. According to the said PPO, the gratuity amount of rupees 7,30,000. Gratuity amount 7,30,000 and pension of 25,150. ये amount मिल जाएगा यहाँ page 13 हाँ. The gratuity amount is 3,65,000 huh? The gratuity amount of 3,65,000.
7,30,000.
Where is, oh sorry, gratuity amount of 7,30,000 and pension is 25,150.
25,150.
Pension is 25,150. Pension 25,001. Enhanced pension of 25,150. Full stop. फिर वही कर देना. He's been outstanding is
5 lakhs.
5 lakhs
49,402.
400
402.
402. Affidavit of service taken on record. Next. सेम वैसे ही हो जाएगा. इसमें रिटायरमेंट, व्हेन इज द रिटायरमेंट? 31/5/2017. All right. PPO
23rd December 2021.
PPO issued on
23rd December 2021.
23rd December 2021. And the said PPO, the amount is 7,30,000 and enhanced pension of 24,400. Outstanding amount is how much?
1,72,774.
1 lakh?
1,72,774.
ठीक है. Affidavit service taken out. Next. Petitioner, retired from service on
31st October 2021.
31st October 2020. PPO issued on
6th January 2023.
As per the said PPO, gratuity amount
6,10,275.
6 lakhs
10,275.
10,275 and pension amount 23,700. 23,700. Same हो जाएगा and amount due is 6 lakhs.
6,08,407.
6 lakhs 8,407.
407.
Petitioner retired on
31st December 2023.
31st. PPO issued
9th August 2024.
as per the said PPO, the gross retiring gratuity is 4,65,075. Pension amount is 17,550. How much is the outstanding?
5,34,043.
5,34,000?
43.
43.
043.
043.
Great, my lordship. My lord, when will the matter will appear, my lord?
Same date.
10th November. Great, my lordship.
Next time, make a chart.
Yes.
Lord, item number 37, learned advocate, my lord, Shobhan Mojumdar appearing this matter, my lord, I'm praying for not today, my lord.
Why?
Due to his death of his uncle, my lord, he unable to appear for lordship today, my lord.
Sorry. Proxy counsel so and so appears and states that the main arguing counsel has suffered a bereavement in his family. He requests for a short adjournment. Let this matter be listed on August 26th.
It will be, my lord.
Lordship, item number 38, I appear on the
Kolkata
petition
Municipal
of
Corporation, it is the matter where Lordship directed to inform the date of cancellation.
Lordship, we have been served on 6th of August with the order of cancellation of mutation agreement.
So what is left?
Lordship, I am praying that the writ petition be disposed of, granting me liberty to file a fresh writ petition challenging this order, Lordship.
You always have the liberty. Learned counsel for the petitioner seeks to withdraw the present writ petition with liberty to file appropriate proceedings in accordance with law. Full stop. Liberty is granted. The present writ petition is dismissed as withdrawn.
Grateful, Lordship.
Grateful, my lord.
Milord, I beg to appear on behalf of the petitioner, Milord.
You appear for the Kolkata
Milord,
Municipal
this is my
Corporation.
affidavit of service, Milord. Well, if I may, Milord, I developed a G+4 structure building, Milord, with sanction plan, Milord. Milord, my sanction plan was granted by the respondent authorities on July 15, 2022. Now, Milord, July 15, 2022, Milord.
Yes.
Now, Milord, thereafter I was constructing the building. Thereafter, on April 5, Milord, the corporation comes to my premises and issued a notice under section 401 of the Kolkata Municipal Act, thereby directing me to forthwith cease all construction activities at the said premises. My lord, the notice, my lord, is at page number 17, my lord. 17, my lord. I'm 17, my lord. The legible copy is in 17A, my lord. The next page, my lord. If I may take your lordship to the notice, my lord. And if I may place, my lord. Reference unauthorized construction at such and such premises, person responsible, owners and occupiers. Sir, with reference in the above, please be informed that on unauthorized construction has been detected at the captioned premises. Building department has served stop work notice under such and such section on the person responsible at the premises to stop further progress of unauthorized construction. In this concern, on you are therefore requested to take follow-up action to provident authorized construction at the said above premises and to keep strict vigil. Now, my lord, in pursuance of this, my lord, if my lord comes up to the later part of the notice, the following information are being below for your perusal. My lord, the notice dated of 401, and number 2, my lord, in person is a sanction plan in respect of the above premises. My lord, they allege there is a deviation from sanction, my lord. Now, my lord, I forthwith stop, my lord, all construction work at the said premises as on April 5, my lord. However, my lord, disputes crop up since, my lord, as it is been seen from the 401 notice, my lord, there are the person responsible for construction is the owners and occupiers. My lord, I was the developer of the property. When the property was constructed till G+4, I sold off certain parts of the property to other third-party shareholders. Now, my lord, there were several people who were responsible for this construction. However, my lord, when, my lord, this notice was served upon all the owners and occupiers, all construction work was stopped. Now, my lord, disputes cropped up between other co-owners of the property. My lord, the other persons I had sold the property to, they instituted suits, my lord, and my lord, I also instituted a suit against another co-owner, my lord, and my lord, an order of injunction was passed, my lord. Page number 25, my lord, is the order of injunction. My lord, there was the suit for partition filed by, my lord, one Dilip Kumar Shah against me, my lord. And my lord, I am contesting the said suit, my lord. However, my lord, as an extraordinary measure, my lord knows, my lord, very well, my lord, the provisions of 400 subsection 8, my lord. My lord, they came to my premises on August 7, my lord, without providing any D-sketch map, my lord, without even indicating as to which part of the building they intend to demolish, my lord. They enter upon the premises with the intent of demolition. And my lord, I am before your lordship, my lord, to my lord pray for, my lord, at least, my lord, my prayer for, my lord, there was no direction by the respondent authorities to hear me out, my lord. I have a valid sanction plan, my lord. Under the statute, my lord, I have a right to be regularized, my lord. My lord, they initiated section 401 against me. No opportunity of hearing was granted to me. That is pending. Now, my lord, they come up, they say, we want to demolish, my lord, without establishing that there was something extraordinary happening, or I was continuing with the construction work, my lord. In this regard, my lord, I am protected, my lord. One judgment of this Honorable High Court, my lord, this passed by Justice Indira Banerjee, my lord, where, my lord, the provisions of section 40 subsection 8 has been dealt with, my lord, and my lord, which says, my lord, that my lord, the reasons that there has to be
They have already passed an order under 408.
my lord, they have passed out, but however, my lord, the reasoning, my lord, I don't know, my lord, they have not indicated the reasoning, my lord. They've also not indicated, my lord, what was so emergent, my lord, for them to come to my premises when there is an admitted injunction, my lord. I cannot construct today, my lord. My lord, in my humble submission, my lord, they ought to have called for a hearing, my lord. I am ready and willing to pay the retention charges, my lord. There is the unauthorized construction as alleged is a deviation, my lord. My lord, I am willing to, my lord, pay all the penalty, my lord, if, my lord, they consider my regulation application. However, my lord, I was not given any time, my lord. April 2025, they issue a 401, my lord. We are in August, my lord. They come and demolish, my lord. My lord, I humbly pray before your lordship, my lord. Kindly, my lord, direct them to call for a hearing, my lord, and consider my application for regularization prior to the demolition of the premises, my lord. Otherwise, my lord, I shall suffer irreparable loss and injury, my lord, because, my lord, I can't even challenge the order under 40 subsection 8, my lord. My lord, this is my humble submission, my lord.
What is the judgment you're showing?
My lord, kindly takes it up, my lord. My lord, SCC 2007 SCC online cal 613, my lord. I shall indicate, my lord. My lord, I humbly pray, my lord, I had one copy, my lord. I shall indicate, my lord. Just give me a moment, my lord. SCC. Calcutta.
Tika, Calcutta.
My lord, this judgment discusses the provision, my lord, of 40 subsection 8, my lord. I shall take my lordship to the judgment, my lord, if my lord pleases me to. Calcutta. Page
You come back after lunch.
My lord, I shall
Get the judgment, come back after lunch.
my lord. Grateful.
Let him come back after. You get a copy of it. Read
I
it.
will. I shall also rely on two more judgments, but I shall come with the copies, my lord.
Come back after.
Okay.
Page number the what? Page number
613.
613.
613. No, 613, Dada. 613. Indra Banerjee judgment. My lord. My lord, if I may place the first judgment, my lord, at my disposal, my lord. If my lord is pleased to take this judgment, my lord. My lord, from paragraph number petition, from paragraph number 57 onwards, my lord, page 10, my lord. If I may place, my lord, paragraph number 57. Having heard learned counsel for the parties and considering the materials placed before this court, it is of the considered view that the only point that arises for determination in these petitions is whether the process of decision making adopted by the mayor in council, culminating in decisions directing that action be taken under section 400 and subsection 8 of the act against several petitions, is the outcome of proper and valid exercise of power or not. Paragraph 58. Intention of the legislature to secure public safety, security, and convenience by conferring power on the corporation to take emergent action overriding private interest is inbuilt in section 408, subsection 8 of the said act. The mayor and council is the repository of drastic powers to direct demolition of a building or work which has been erected, commenced, contravening the provisions of the act forthwith, without granting any opportunity of hearing the petition, the person to be affected thereby, if in its opinion immediate action is called for. These are two factors which must exist before an order can be passed under section 408, 40 subsection 8. The only safeguard the concerned statute provides to the person to be affected is that the mayor and council must record reasons in writing for directing such demolitions for building or work forthwith. Obviously, the reasons must be valid and germane and not fanciful and arbitrary, and must establish that immediate action is called for. Paragraph 59, there cannot be any exhaustive enumeration of situations, incidents in respect whereof an immediate action may necessarily be called for. However, it seems to be beyond any controversy that if any construction is made without the authority of law, and that would hinder public interest if allowed to remain, definitely recourse to section 400 subsection 8 of the act would be justified instead of initiating action under section 401 thereof. These would include construction which impede public convenience and or endanger public safety and security. In such cases, urgent action has to be taken to subserve and safeguard public interest, and the right of a pre-decisional hearing of a person responsible for raising the impugned construction must necessarily and inevitably succumb to overwhelming public interest consideration. Paragraph 60. The contentions of Mr. Bihani and Mr. Banerjee that even if a construction is raised without a building plan, action in respect thereof can be taken under section 401 of the act or 402 thereof, and consequently action under 408 would be warranted and is misconceived. In the decision such and such, it has been held that action under 40 subsection 8 can be taken if there are grounds satisfying the condition of subsection 1 of section 400, and that too only after complying with provisions contained therein. Mr. Bihani, having admitted that Sunil, the petitioner therein, has erected the concerned building without obtaining the sanction of the corporation, there is ground for proceeding against him under section 400 subsection 1, and hence in the view of the law laid down in Manoj Devi Supra, action under section 400 subsection 8 cannot be faulted. Besides this, section 408 itself is an overriding provision. It permits action being taken notwithstanding any other provisions contained in the act. Erection of a building or commencement of work without sanction of a plan is a contravention of the provisions. Therefore, in an appropriate case, the mayor in council would definitely be justified in exercising power thereunder, notwithstanding the fact that that action could have been taken under 400 and section 400 and subsection 1 or under section 402. My lord, here, my lord, I stop, my lord, and I say, my lord, that when, my lord, in April 5, 2025, when the stop work notice was issued upon the owners and the occupiers, including the petitioner, we forthwith seized all construction activity, my lord. My lord, there was an order of injunction, my lord. So, my lord, I would not, my lord, in any case, my lord, endanger public safety or public health, my lord, or, my lord, these deviations, my lord, which were indicated in section 4 in the stop work notice, would say, my lord, that these deviation is today causing a danger or it's impeding on the public convenience, my lord. My lord, I shall, my lord, take my lord to another judgment, my lord, which of the Supreme Court, my lord, if my lord takes it up, my lord.
So this is all you have to read in this one, right?
Ma'am, this year, my lord. My lord, paragraph 20 onwards, my lord. My lord, paragraph 20, my lord, if I may place, my lord. Considering these aspects, Sri Arya submits that there is no merit in contention that construction of a building by appellant was in violation of license granted or that the license under the construction was undertaken contrary to statutory provisions or other orders. The public is in no manner aggrieved by the construction of the building. No member of the public has come forward to say that his privacy has been affected by the construction of the building or safety of the neighborhood or of the inmates of the building has been in any manner endangered. The or one of the respondent counsel says it is neither a resident in the neighborhood of the building nor he is a person affected by the construction of a building. He has neither any personal grievance to vindicate or any public cause to espouse in challenging the validity of the license, my lord. My lord, this is on the fact, my lord, that the public in no manner is affected by deviations in the building of the petitioner, my lord. Therefore, my lord, I shall place reliance on, my lord, this paragraph, my lord, and the subsequent paragraph, the Supreme Court holds, my lord, that, my lord, if, my lord, the High Court had, in that case, my lord, directed demolition, the Supreme Court holds, my lord, in paragraph 21, we have perused the records and considered the arguments on the both sides. We are not satisfied that on the facts and circumstances, the learned judges of the division bench of the High Court were justified in permitting and much less directing the demolition of the sixth floor, my lord. My lord, if my lord permits me, my lord, I shall take my lord to the another judgment of 2011 of this Honorable High Court, my lord, by my lord Justice Indira Banerjee, my lord. Well, this judgment considered whether compliance with principles of natural justice is essential for demolition, my lord. Page number 15 onwards, my lord, I shall, my lord, indicate, my lord. At the bottom, my lord, as observed above, there are two sets of provisions for demolition of premises. The provisions of section 400 governs illegal and unauthorized constructions in disregard of the applicable rules and or without sanction plan and or in contravention of the building plan. Section 411 governs demolition of unsafe buildings. Legislature in its wisdom made separate provisions for demolition of unauthorized buildings and for demolition of unsafe buildings. May be in certain rare cases, a building could be unauthorized and also visibly unsafe, in which case it might be open to invoke power of demolition under section 400 subsection 8 or under section 411 subsection 4 of 1980 Act. The condition precedent for exercise of power under section 400 subsection 8 is the formation of opinion that immediate action is called for, my lord, called for in relation to a building or a work being carried on or in contravention of the provisions of the 1980 Act. The construction may be forthwith demolished for reasons recorded in writing For formation of opinion of the necessity of immediate action, it is not necessary that the building should be unsafe or dilapidated. Any construction without sanction has to be deemed unsafe as sanction is granted after examining structural safety aspects and other clearance from the Fire Services Authority. Section 400 contemplates action in all cases of unauthorized construction, be it unauthorized construction in contravention of the applicable building rules, be it commencement of construction without sanction of building plan, or be it deviation from section. Rule 26 subsection 2 of the Kolkata Municipal Corporation Building Rules 2009 provides for regularization of deviations upon payment of penalty. My lord, the judgment is sets out the rule 26, my lord, and my lord says power to regularize an unauthorized construction is wholly discretionary. In any case, contravention of mandatory provisions of statute and major deviations cannot be regularized. For example, infringement of a mandatory open space required to be maintained can be regularized. What may be regularized is an unintentional deviation, minor and or trivial in nature. For exercise of power of regularization, the authorities concerned would have examined if the building could have been sanctioned had the deviations been indicated in the application or for the sanction plan. For example, where sanction of a building is sought showing 10 feet wide open space, which is in excess of 6 feet required under the applicable rules, deviations during construction, which infringe into open space may be regularized subject to payment of fine, provided the minimum mandatory open space required as per the rules is maintained. In no circumstance can construction without sanction be regularized, such construction being contrary to the statute. My lord, I say, my lord, that, my lord, I had the sanction plan, my lord. In the section 40 stop work notice, my lord, they say, my lord, there are deviations, my lord. That has to be found out, my lord, what deviations are there by way of an inspection conducted by the corporation. My lord, I put the respondent authorities on the strictest proof thereof, my lord, to submit there was an inspection of the premises before the demolition work was undertaken. Then, my lord, I say that, my lord, if, my lord, these are deviations, they, my lord, do not come under any public safety or public inconvenience, invoking them their jurisdiction of emergency powers under section 400 subsection 8 of the KMC Act, my lord. And, my lord, that too, my lord, I say, my lord, the step, my lord, that the respondent authorities have taken, my lord, is devoid of any reasonable reasoning today, my lord. My lord, I humbly pray before your lordship, my lord, I am willing to, my lord, deposit any payment of penalty, my lord, if, my lord, they consider my regularization application. Now, my lord, in the instant case, my lord, they have not given me any opportunity for me to make an application for regularization of the deviations, my lord. My lord, I again say, my lord, when they initiated the proceedings under section 400 and subsection 1, my lord, I was waiting to be provided and hearing, my lord. That was also taken away from me, my lord. Now, my lord, they are at my doorstep, my lord, waiting to demolish, my lord. They say, my lord, the entire structure, my lord. This is my, my lord, humble submission before your lord.
Yes.
Yes, my lord.
So you're challenging the work stop notice or the demolition order?
My lord, I'm only challenging the demolition order, my lord.
Where's the order?
My lord, if I may take, my lord, to the prayers of the writ petition, my lord.
But where's the demolition order?
My lord, we have not been served with. They say, my lord, we can't.
How are you challenging it when you don't have the order?
My lord, I have the prayers, my lord. It's in page number 12.
That's
my lord.
right, but where's the order?
My lord,
Prayers will not suffice for your order.
They have not supplied me the order, my lord.
Then how have you approached this court without
lord,
the order?
I have been informed by the respondent authorities.
Information doesn't help, sir.
My lord, I have not been served. They say, my lord, I have no right to be served.
Then how can you say that a demolition order has been passed? What are you challenging?
My lord, I am challenging,
you have to
my
put
lord,
the demolition order here.
My lord, my lord.
Where's the order?
My lord, my lord, when, my lord, my lord, if my lord remembers, my lord, I had taken leave for this application, my lord.
Application is fine. Where's the order?
My lord, the order, I had no opportunity, my lord. I had repeatedly asked the respondent authorities to serve me a copy of the order, my lord. They say, my lord, under the powers, they are in not a position to serve me any order, my lord. My lord, I humbly submit, my lord. There are.
You should have stated so.
My lord, my lord,
what have you stated?
My lord, I shall, my lord. My lord, page number 6, my lord, paragraph number 11, if I may take your lordship. Your petitioner states that the petitioner had no knowledge of passing any order inasmuch as when the petitioner requested the respondent number 6 to serve a copy.
I'll dismiss this only on this ground.
My lord, kindly, my lord.
I'll dismiss it on this ground.
My lord, they had not served me. My lord, kindly appreciate, my lord. My lord, they
Give a copy. Give a copy of the order.
I tell you, lordship.
Give a copy of the order.
I have already, I guess. Name or
Withdraw this, challenge the order.
my lord, till then, my lord, if my lord.
My lord, may I just indicate one thing?
Yes.
But I had marked this that he has not challenged the order in the prayer portion. But bereft of that, my lord, kindly sees the provision of 400 subsection 8.
Yes.
But will your lordship kindly have this page once? This is the.
Where's your reasoned order?
Right,
Show me the order.
400 subsection 8, my lord, visualizes an emergent provision. Order to the. My lord, kindly sees it is first placed the emergency is placed, then it's sent before the mayor in council. That is the position which has been upheld by the virus, has been upheld by this honorable court. So the two factors are, if it is emergent and it is safety, endangering public safety, no order is passed, the process is taken for, after serving of the notice of 401, process is taken for demolition. The virus of this was challenged, it has been upheld long back. Now, my lord, I'm sorry.
Explain করা আছে।
How is the unauthorized construction unsafe?
My lord, the lordship has seen the top portion. Now this was placed before the mayor in council. Kindly sees the bottom portion resolved in mayor in council dated 30th May. But if your lordship kindly goes through that, starts with considering the facts and circumstances. This is the resolution of the mayor in council.
Yes.
Well, may I just place it?
By merely stating it that it is unsafe and can cause accidental hazard and may
Accident
also
hazard
cause...
may also create several others like fire hazards and environmental hazards, etc.
What is the background to this?
My lord?
What is the background?
Background. Now, my lord, kindly comes to the first paragraph of that order.
First paragraph also I've seen.
By kindly sees.
What accidental hazard?
I'm sorry, my lord.
What accidental
Well, by
hazard?
encroaching the mandatory side open space and changing the parking position, it is also found that the open space at the rear side and southern side has been covered by GI shed fully.
So,
now, my lord, if I may place before your lordship a judgment of 2023
yes,
of the honorable division bench, if your lordship allows me to go step by step, this honorable division bench, my lord, in two separate judgments by the honorable two separate judges, records, I'll place it before, records that not only this accidental hazards and all that, but if a builder is allowed to go on making constructions, even then 400 subsection 8 will apply.
Give the judgment.
Lordship. This is, my lord, kindly takes a copy of this. This is, I don't think it's reported. This is, my lord, dated 21st of August 2023. Now, my lord, may I take your lordship to certain paragraphs, or I will take your lordship directly to that paragraph?
You take me whatever you want.
Lordship. Now, my lord, kindly takes, my lord, paragraph 18 first, which is at page, my lord, I tell your lordship, page 11. Now, I'll kindly skip, I'll not tell your lordship. 18 and 19 is paragraph 19, my lord, kindly sees at page 11. This refers to a municipal corporation regularization of buildings regulations, wherein, my lord, what is minor has been defined.
Yes.
Now, my lord, now takes paragraph 27, which is at page, my lord, 16. Because, my lord, kindly sees, from the above, it is crystal clear that the appellant has no absolute right to claim that his valuable right of hearing has been violated by the corporation. 16, my lord. 1-6. At the bottom, paragraph 27. From the above, it is crystal clear that the appellant has no absolute right to claim that his valuable right of hearing has been violated by the corporation by taking steps under section 400, subsection 8 of the Act of 1980. Well, if your lordship sees section 400, subsection, doesn't speak of violation. Now, my lord, now takes paragraph 32, which is at page 20. Needless to mention that unauthorized construction has become a menace to our civilized society, and the extent and magnitude of such unauthorized construction in every nook and corner of our country has reached an alarming proposition. To curb the menace, the Honorable Supreme Court as well as the High Courts have shown zero tolerance to such unauthorized constructions. Sorry, the unauthorized constructions which jeopardize planned development have been seriously deprecated since the same are against the societal interests of our country. The society has certainly a legal right against citizens not to make any unauthorized constructions since it militates against the planned development, environment illusion, so on. As a custodian of social interests, societal interests, the municipal authorities have been empowered by the municipal laws to see and check that no such unauthorized construction is made under their respective jurisdictions so that societal interest can be preserved for the sake of the public at large. This aspect of societal interest cannot be ignored, and in several judicial decisions, such interest of society has been kept in the forefront. In our case, the provisions of that regulation of 2015, my lord, we shall find that the societal interest has been given a very important place. Regulation 4 of provides that any unauthorized erection or work may be regularized by the municipal commission or any of its officers delegated, provided that the erection work is determined by the municipal commissioner and other as a minor as per regulation such and such. Therefore, the appellant has also a duty towards the public or society. Then, my lord kindly sees, as third proviso 401, has been the KMC indeed has a duty to protect the social interest aspect and can certainly demolish the unauthorized construction under section 400 subsection 8 if it affects social interests as aforesaid. Well, this is number one. Now, kindly see the next paragraph, paragraph 33. Another contention of the appellant is that the procedure for passing an order under section 408 of the Act of 80 was not properly followed by the mayor in council, and therefore the said order is illegal and arbitrary. It is claimed that the stereotyped orders being passed by the mayor in council for last 17-18 years in respect of similar cases. The appellant has also doubted the authenticity. This was his submission. Now, Lord takes last two paragraphs, 40 and 42. Lord, you will find that, my lord, at page 26 at the bottom. Sorry.
Page 40.
Lordship, if it is found from the said provision, there is no prerequisite condition mentioned in subsection 8 of 400 that there must be some grave emergency or imminent danger to public safety or something like that. In my considered opinion, it is a settled principle of law or of interpretation that when letters of law are not ambiguous or are not susceptible to different meanings, neither any word or sentence can be added to such clear unambiguous provisions of law. Taking a cue from the said rule of interpretation, in my view, if the mayor in council opines that immediate action is required for demolition of a building or work which is being carried on in contraventions of the provisions of the Act, the mayor in council, after recording reasons, may ask the concerned department to proceed with the demolition work forthwith. The said provision of law does not require the mayor in council to consider whether or not there exists any grave emergency towards public safety or imminent danger for such unauthorized constructions. But on the other hand, it is sufficient that if after considering the contraventions made by the person responsible, the MIC is of the opinion that immediate action for demolition of the building or work as aforesaid necessary, the case in hand is one of such instances. Now, my lord, kindly takes, my lord, if your lordship goes to page 30, this is the, my lord, judgment by the presiding judge, my lord, Justice Banerjee. Well, Lord Trouble, your lordship kindly takes, my lord, paragraph 10, which is at page 33. And paragraph 9 and 10, my lord, kindly takes page 32 first. At the bottom, lordship will find paragraph 9. My lord, may I place it?
Yes.
Lordship. At the bottom, the Kolkata Municipal Corporation Act is a regulatory piece of legislation. That statute not only empowers but also imposes an obligation on Kolkata Municipal Corporation to exercise supervisory control over any kind of construction raised by anybody within the territorial limits. Under the statute, no building or structure apart from a few exceptions spelled out in the Act can be put up within the corporation area without prior sanction of KMC. KMC has framed building rules in accordance with which the building plans are sanctioned. The state legislature has promulgated the Act of 80 to not only regulate construction of buildings, sets, and structures, but also to provide civic services in the forms of such and such. Removal and disposal of solid waste, fire prevention, fire safety, maintenance, etc. The rules that KMC lays down in the exercise of powers conferred under the Act are statutory rules having force of law. When a citizen is faced under such, he is obliged to follow. Then kindly takes paragraph 10. The emergency power in section 400, subsection 8 of the KMC Act has been reserved to the mayor in council to take immediate action for demolition of a building, not only when such unauthorized structure is an imminent threat to the safety and security of the life and property on the same, but also, in my opinion, when an adamant builder continues with the unauthorized construction, defying the notice issued by the civic authorities in exercise of statutory power and in discharge of statutory function. If an unscrupulous or recalcitrant builder is permitted to carry on with unauthorized construction with impunity in violation, an important object of the act will be defeated. This cannot be permitted. Now, my lord, vis-a-vis this, kindly takes, my lord, the provision why 400 subsection was imposed in this case. And if your lordship goes through his decisions,
yes,
kindly takes his first decision cited by him, which is, my lord, 2007 SCC online 613. But I found that in this case, I had represented the petitioners. Now, my lord, kindly take certain paragraphs of this. Paragraph 58, kindly, I think my learned friend has placed it. Kindly take paragraph 58. My lord, over here, my lord, subject to your lordship's correction, two factors were decided. Now, this is as back in 2007. Well, when rampant unauthorized construction and not that rampant over here. Kindly takes paragraph 58 once. Well, this is internal page, koto data? Internal page 9, internal page 9. No, age over page 9. Internal page 9, either. Lordship has got it, no, paragraph 58?
58, yes.
Lordship.
Yes.
Lordship. Intention of the legislature to secure public safety, security, and convenience by conferring power on the corporation to take emergent action overriding private interests inbuilt in section 408. The mayor in council is the repository of drastic powers. Lordship will skip this. Not required. Without granting any opportunity of hearing the persons, if in its opinion, immediate action is called for. These are the two factors which must exist before an order can be passed. So, my lord, immediate action is an important, is the only consideration factor.
Two factors is talking about is public safety and security.
Public safety and immediate action is required. Now, my lord, this is in 2007.
Factors, when he talks about factors, then
now, my lord, that in my response submission in 2023 by the division bench has been explained that what can be, even if it is not so. So, my lord, I was trying to conjointly read this with the 2023 decision. That is
2024 has enlarged the scope. It is not only limited to public safety and inconvenience. It has
because
beyond
that is why I submitted this in 2007. The rampancy was not that to that extent, which is now today, before your lordship. So that is number one. Number two, if your lordship now takes his second decision, which is my lord lordship, the royal, this is a celebrated case of Rajatha Enterprise. My lord, this speaks about my lord, he has relied. My lord, kindly takes paragraph 20, which my learned friend has relied upon. The penultimate page.
That is a different thing.
Penultimate page, paragraph 20. That says if the public is not agreeing, that is the law as lordships have now changed. Paragraph, the third decision which my learned friend placed.
Kindly also similar to 2007 one.
2007, but there is one important I found subject to your correction. Number kindly takes page 16 of that judgment. The second paragraph.
Yes.
The condition precedent for exercise of power under 408 is formation of the opinion that immediate action is called for in relation to a building or work being carried on in contravention of the provisions. Construction may be forthwith demolished for reasons to be recorded in writing. For formation of opinion of the necessity, it is not necessary that the building should be unsafe or dilapidated. As back in 2011 also this was the position. Then kindly see the next paragraph. Any construction without sanction has to be deemed unsafe as sanction is granted after examining structural aspects and after clearance from the fire service authority. Section 400 then kindly goes on. Well, it kindly takes the last paragraph, next page. Power, my learned friend was speaking about regularization. But in 2011, the Honorable Court has said it is purely discretionary. But kindly, my lord, vis-a-vis this, kindly conjointly now comes to the order, my lord, once more.
So the biggest fault is that he doesn't have the demolition order, which is challenging.
My lord,
So
under 400, my lord, under 400 subsection 8,
he'll challenge it. He'll withdraw this
under
writ
the
petition.
act, my lord,
You withdraw this writ petition, challenge this order. Learned counsel for the petitioner has preferred the present writ petition, challenging the demolition order dated. What is the date?
Well, this is dated
30th 5
30th May 2025.
30th May 2025. Full stop. The petitioner had filed the present writ petition without the impugned order. Full stop. Petitioner states that he was not provided with the impugned order. Be that it may, this court is not getting into the issue whether the petitioner was handed over the impugned order or not. Today, the respondent has handed over a copy of the impugned order to the petitioner. The petitioner seeks to withdraw the present writ petition to file appropriate proceedings in accordance with law. Liberty as prayed for is granted. the present writ petition is dismissed as withdrawn.
Deeply obliged.
Deeply obliged. ये मेरे चैम्बर एक वो बना दो एक टैग करके
No, sure. Item number 40, I'm
40, Your Lordship. Ms. Sheboti Dotto is appearing on behalf of the respondent number 5, Your Lordship. Lordship, she has some personal difficulty, Your
For
Lordship.
the corporation matter, we have already submitted a report in the earlier occasion. We have to submit a exception to that.
No.
Not yet we have got any exception at least.
Lordship, I
Madam, last time also you said the same thing.
No, Lordship, in the last occasion, the report was filed by the municipal corporation, Your Lordship, and Lordship give me the time for 2 weeks for filing the exception, Your
Yes, so
Lordship.
where is the exception?
Lordship, the exception is not right.
Forget it. You are the private respondent.
Lordship, respondent number 5.
Yes. Where's the exception?
Lordship.
Lordship, I pray for 1 week accommodation, Your
No,
Lordship.
no, madam. These private parties, they keep taking time on all these matters.
May I be permitted to file the exception and the affidavit in reply, Lordship? The private opposite party, they have filed an affidavit in opposition. We have preferred an affidavit.
Can a copy be given?
Lordship, I am handing over.
Exception to the report filed by the respondent corporation is taken on record. Affidavit, reply to the affidavit in opposition filed by the private respondent number 5 is taken on record. Yes.
Yeah.
Where's the brief, madam?
Lordship,
Where's your brief?
Lordship, actually, my senior is not present, Lordship.
Senior sends you without a brief.
No, Lordship, there is some difficulty. I pray for apology, Your
Where is
Lordship.
the brief? How can you appear in the court without the brief, even if you are taking time? Is this what you learned from the chamber? That you should come to the court? Is it a garden? Have you come here for a stroll? Please carry a brief.
I pray for apology, Lordship.
How can you appear without the brief? Even if you're taking time. What kind of a practice is this? Who's your senior?
Ms. Sheboti Dotto, Your Lordship. She has some personal difficulty, that's why I'm...
Whatever it is, madam, I'll give you time. Where is your brief? As a junior, how can you appear without the brief? Even if you're seeking time. How can you come to the court without the brief? You're not supposed to enter a courtroom without the brief. What is there, Mr.
Lordship.
Fourth floor to sixth floor is without any sanction. And
We have filed this writ petition, Lordship. There was a sanction of a G+3 storied building. In addition to that G+3 storied building, there has been a construction of 4 additional floors. Our grievance is that those 4 floors have been made without any sanction plan, Lordship. The private respondent, they have in their affidavit in opposition, they have submitted that those floors have some of
You're
those
admitting
floors
it,
has
Mr.
been-
Banerjee, then you take action.
We have already issued self-admission notice. Now we have to go for demolition.
Demolish the properties.
Lordship,
What is
only-
stopping you?
May I just indicate only one thing, Lordship, from
Yes.
their report. Lordship, if your Lordship may kindly takes up their report, the last 2 page, Lordship, your Lordship may find that on 21st of May 2025, the self-demolition notice was issued. Subsequently, where it was directed that the unauthorized construction, in the last paragraph, Lordship, I such and such hereby direct you to demolish the said unauthorized construction as outlined below within 15 days from the date of receiving this notice. If your Lordship may kindly take, since then no action has been taken, if your Lordship may kindly take the next page, that is on 3/7/2025, a reminder notice has been sent, Lordship.
Well, their prayers are there.
Lordship,
Their prayers at page 11 and 12.
And if your Lordship may kindly also
prayer
peruse
is
the
against the
demolition,
unauthorized construction to
their
initiate
notice,
appropriate-
Lordship, there was, it was the self-demolition notice, there was some blanks, Lordship.
The prayer is initiate appropriate proceedings for demolition. That prayer has been taken care of and already initiation done and completed. And now demolition, that will be done immediately. So their prayers have been taken care of and we are going to demolish it because 3 extra floors, it is a headache to us also.
So your
We have already completed the proceeding.
you have report is this 2-pager which you have filed. Where's the report? Give me a copy of your report. Just these 2 pages which you have filed.
No, not 2 pages, madam. Yes. Here are annexures also there.
Just show me.
The Lordship may kindly take the last 2 pages of the report. Then after 2 months, no steps have been taken and they have suddenly issued a reminder, Lordship.
We'll have it next week.
Grateful Lordship.
We'll have it next week.
But only clear service in my lord. At January 25, they have filed it. To initiate proceedings, they have said, we have already initiated, we have concluded. Now, because we have come to a conclusion, we have found 3 extra floors. Now we will immediately we will give notice of demolition.
So do that before the 26th.
If your lordship, given that lordship. Only if your lordship gives it, place it after vacation, my lord will come. I will come. That demolition has already been
After
started.
vacation, I'll be out. You will do nothing.
No, I will do my lord. In any manner, my lord, keep it up.
That is
After
what
1 week,
the way you are dragging your feet on this.
No, we will fix a
2017.
date for demolition. My
There
lord.
is definitely vested interest here.
My lord, I will.
After holiday, this will also go for a holiday.
I will after 1 week, my lord will see that I have kept it. Demolition dates have been fixed. Also.
All right. So we'll keep it. When do you want, Mr. Banerjee?
Any day, as your lordship. I will come with demolition dates.
26th August.
26th August.
Great.
I will come with demolition dates.
At the request of the parties, let this matter be listed on 26th August.
Great.
And next time, don't enter my court without brief. Or any other court. At least this much you should know.
26th. 26th August.
26th August.
Great.
Lord 41, my lord, I am for the petition. May I just remind your lordship, my lord, in this matter, my lord, initially the direction was passed by the coordinate bench during pendency of the writ petition. My lord, though there was a specific, though there was a specific order of injunction, but still, my lord, 2 additional floors have been constructed in a teeth of an order of injunction passed by this honorable court. Thereafter, my lord, I approached before your lordship. They ultimately passed a demolition order, which is page 27 of my lord's brief. My lord was, my lord, taking steps, my lord, by persuading the machinery of the municipality so that the demolition can be carried out. This order can be implemented. Now, my lord, in the interagnum, my lord, during the vacation, summer vacation, they moved before the honorable division.
They moved in private respondent.
I my lord, never intended, my lord, Mr. Banerjee's client. They moved before the, my lord, the division bench. The division bench ultimately not considering that there was a prayer for regularization that is pending at the end of the corporation, Milord gives them a window that so the corporation may decide, the commissioner is the authority. Milord, there was a time limit. Milord, again, the matter came up before your lordship on the last occasion. Your lordship directed Mr. Banerjee that since there is a decision, you have to take it. So your lordship kept it today so that Milord, the thing can be expedited. Milord, I can give your lordship, my client till date, Milord, have not yet received anything, Milord, from the corporation that I hear. Mr. Banerjee assured this court, Milord, that this, yes, Milord, this will be done within at least 1 month.
My learned friend also know in many of the regulation cases, some time is required. Let some time be given as per order of the division bench and also as per order of this honorable court. We will complete the demolition and we will complete the regulation prayer. And I have already submitted before the honorable division bench that will end in demolition. We cannot regularize. That also have been submitted before the honorable division bench. But I may seize the division bench order also. In any
But I have shown before your lordship on the last.
I will come with the order of rejection.
How much time?
But I leave it to your lordship.
Stay for 4 months, my lord. Let that be a stay for 4 months, but I will come.
Milord, the stay is, Milord, for their consideration.
Or any day before the.
Milord, after vacation, Milord, Mr. Banerjee, how much time, Milord? A single day hearing. There was no regulation I can place, but today, Milord, I am not.
You file a report, Mr. Banerjee. Let him file a report.
Earlier occasion, he filed a report, Milord. Your lordship was not happy with the report. Thereafter, your lordship directed another report to be filed.
In any manner, if your lordship keeps it in the September, I will come with the rejection order also. I'm sorry, I am saying in the
All right, you
I
can
come with the rejection order.
Learned counsel for the respondent corporation seeks and is granted 3 weeks time to file his report indicating the decision taken on the respondent's plea of regularization.
Right.
Full stop. In case the corporation rejects the application for regularization, then the corporation shall also submit a report indicating the steps taken to comply with the orders passed by this court.
Rejection or consideration or allowing, that will take 3 weeks at least. Thereafter, my compliance, that will take some time.
Let him come, Milord. Let him come at least, Milord.
Maybe
4 weeks. Give him 4 weeks. 4 weeks.
Very well.
4 weeks. You are seeking basically the implementation
of page 27, Milord, which was passed, Milord, on 22nd of January 2024.
And division bench have stated that only to give us them time that we will consider their regularization prayer because it is a G plus.
Milord, 2 additional floor.
Made a prayer for regularization, my lord, and second did, my lord. That prayer has not been considered as yet. Consequently, my lord, I filed the writ petition.
Second writ petition, Milord, subject to correction, Milord. Second writ petition is for, Milord, the challenging the demolition order.
G+1.
This page 27, they have challenged.
G+1 building. That is the building.
The first writ petition is basically for implementation of the order passed, and the second one is challenging
page, yes,
which is filed by you.
Yes, my lord.
Right? That is the reason why both the writ petitions were taken up together.
Yes.
My lord.
Thereafter, against that, they went to the
Admittedly, Milord, there is no sanction plan. Ground floor is an old one. That's why municipality considered the ground floor to be retained. But the additional 2 floors have been constructed without any sanction building plan.
And that was required to be demolished. Consequently, my lord, I made a prayer for regularization, my lord. That has not been considered.
Yes.
I have filed the writ petition, my lord, which is item number 42. My lord, on 3rd of June 2025, my lord, The Honorable Division Bench.
My learned friend is saying that
Municipal
for
Corporation
non-consideration of his regularization pair,
Because of the writ petition of the private respondent, my lord.
Sir, the moment your application for regulation is disposed of, whichever way, your demolition action is based on that. Nothing more. You can't have a better footing
No, my lord.
than what it is today, except that your regulation application is pending.
But deviations also we cannot read. That we have submitted before the court, honorable court, but honorable division bench said that you please consider it. That is was the
And what is that rule 26.2? Which rule under the Havra Municipal KMC is 26.2? What is your rule?
regarding.
Regulation.
Regularization, your third proviso appended to section
Yes.
177. Third proviso appended to 177 gives them a power,
Regulations
but
are-
provided they will have to frame a regulation.
Yes.
But no regulation as yet is being framed.
No regulation frame.
That's not the
Then
honorable.
how can you do it?
This
We
is
cannot. We cannot.
like in
I
Kolkata
have
Municipal Court.
submitted specifically before the honorable division bench. I don't know it was a vacation bench. I don't know. But
I
that-
was not, my lord, I could not able
we-
to assist the
I-
court because my client on that very day got the copy of the appeal, and on that day, my lord, the matter was heard.
in any manner.
That's why, my lord, I could not assist. Otherwise, my lord, I my lord, could have assisted the honorable division bench. One of the judgment are also there. Since no regulation has been framed, there is no window open. Like, my lord, in 2015 in Kolkata Municipal Corporation Act, they framed a regulation.
And there is third proviso, there is written that provided
Just-
also
just-
that the
just
commissioner
stay down.
may by order
The
on such terms.
learned counsel for the respondent, Mr. Banerjee, states that the division bench in MAT number 823 of 2025, while it's already dated 3/6/2025, had given a direction to the respondent, Havra Municipal Corporation, to decide petitioner's representation dated 20th February 2024 within a period of 4 months from the date of communication of the order. Full stop. The 4 months comes to an end when?
October, in my lord, October, 6th, 5th of.
Full stop.
That is the outer
Part
line,
of-
my lord, given. Yes.
4 months. Full stop. He states that the representation has yet not been decided. Full stop. He seeks and is granted further time to file his report, bringing on record the outcome of the said representation. The outcome of the said representation as directed by this court in MAT number 823 of 2025, while order dated 3/6/2025. Full stop. Let this matter be listed after vacation. There's no point keeping it in October. After vacation, 10th or 11th, you're saying? 11th. We can keep it after also. Any other? Give me dates which are easier for you. Twelfth?
12th October.
12th November.
November.
October, we will all be
Holiday.
so let that come, then we will see.
That will definitely come. Demolition.
We know the outcome. If you don't have a regulation, then
I know, he also knows.
you would have done it now. We would have
The
disposed it.
fact is this, as far as the consideration by the commissioner, that is going on.
एक line और लिखे ना.
In any manner, I will come.
That if the report if the representation is if at all the commissioner at the time of deciding the representation is not able to regularize the deviations or the unauthorized construction in accordance with law, the respondent shall indicate steps taken in pursuant of the demolition order dated 21/1/2024.
Steps to
I'm
be
good.
taken.
Steps to be taken. Steps to be taken in terms of the demolition order dated 22/1/2024. 41 में ये order होगा. Second, the petition is tagged along. There's no order. Nothing is required in that. It will all depend on the outcome of this.
Great.
Great.
My lord. Item number 43. In this matter, my lord, I am appearing for the petitioner. In this matter, my lord, there was an earlier order by this honorable court that the unauthorized construction of two additional
43. What is it?
two additional floors that were constructed beyond sanctioned plan be demolished by an order dated 1st of April 2024. This honorable court directed, but that order, my lord, has not yet been implemented. The matter was taken.
You are there.
I do not know whether your lordship would be taking up this matter because the orders by which corporation was directed to demolish
Yes.
was carried out in appeal. The name of Susanna Anthony and others.
Yes.
And your lordships sitting with my lord Mr. Justice Joymallo Bakchi
Oh.
decided this matter. But anyway,
how can I?
no, your lordship.
My lord,
the appeal was carried against because those orders.
No, my lord, if I may, if I am permitted to submit before your lordship, that appeal has already been dismissed, my lord.
Mr. Dev,
I'm
sorry.
placing that order. Are you listening to me?
the problem is when you appear virtually, you don't listen to the other side. You only want to speak your own. We will have it when you are available. When are you available in the court?
My lord, on 21st, I'll be returning from Delhi.
All right, we'll have it after that.
Very good.
Not today.
My lord, keeps that decision bench judgment in your lordship's record.
Yes, what is
Appeal.
there? I should transfer it then. I shouldn't hear this matter. What is there, Mr. Mukherjee?
Your lordship has affirmed the order of the trial court by which corporation was directed to demolish.
Right.
Now, my lord, thereafter we had been taking steps. It is fully tenanted. Tenants, as your lordship knows, tenant doesn't. They will not purge out from the illegal portion. Then, my lord, we have written to the police.
Yes.
To take steps only with that.
No, what is my, this is.
Police is also not taking any step to get the vacated, unless I get a vacated premises, I cannot go on for demolition work.
Susanna Anthony is the
In
respondent.
respect of those orders, in terms of which my learned friend is seeking implementation, I'll just give it to your lordship.
No, but if I have heard the matter in division bench, then how
Yes,
can
your lordship has
No, my
heard.
lord, that matter has been disposed of, my lord.
That's right, but I've been a part of that division bench, sir.
বুঝে না যদি না বুঝে তাকে কে বোঝাবে?
That was a single bench order, my lord.
Let this matter be listed before another bench, subject to orders of the Honorable Chief Justice, since one of the judges, that is me, was part of MAT 1146 of 2024, which arises out of an order passed in the present writ petition.
All right. I'm sorry, I have missed that part which my learned adversary submitted before your lordship, that your lordship was a part of that division bench. I
Yes.
might have missed that. I'm sorry. Grateful.
No, my lord, I beg to appear on behalf of the petitioner. This is my affidavit of service. And by the impugned order passed by the respondent number 3 being the Commissioner Bidharnagar Municipal Corporation, the trade license which stood in my name since 2006 in the name of the petitioner, that has been declined to be renewed. Up to 2017-18, there was a renewal. Subsequently, the private respondent, being the writ petitioner in the earlier writ petition, alleged, made some allegation which was countenanced by a filing of a writ petition by the coordinate bench, and the coordinate bench directed the Bidharnagar municipality to consider the representation but not to go into any civil disputes. Not to be considered. But the facts remains there was a memorandum of understanding between the writ petitioner and the husband of the private respondent. Both are full-blooded brothers. They started a business named Auto Trade Center. But that was being run up to the demise of the husband of the private respondent till 2004. After the demise, but there was a fresh agreement being entered into by the writ petitioner and the private respondent. Subsequently, thereto, my lord, the private respondent signed a dissolution of partnership and took away the money that has been maintained, that has been parted with in the partnership deed, and reinvested it only on the getting interest over the principal amount. My lord may kindly seize the dissolution of partnership. That has not been expressed in the earlier writ petition. Kindly come to page 28. I will only take your lordship to the relevant portion. Page 28, it is a deed of dissolution of partnership.
First, you tell me, sir, you were two brothers.
Full-blooded brothers, husband of the private respondent and the writ petitioner. There was a memorandum of understanding between the two brothers.
Where is that?
My lord may kindly comes to page 17, 17. This memorandum of agreement between Vidyut Roy, who is the writ petitioner before lordship first partner, and Sri Biman Roy, both fathers' name your lordship will find same Shailendranath Roy as the second partner. There was a
Roy and
yes, my lord,
Biman Roy, right?
Yes, Biman Roy. Biman Roy happened to be the husband of the private respondent.
Husband of the private respondent.
Private respondent. They kindly see the father's name. Both are of son of Sri Shailendranath Roy. Vidyut Roy and Biman Roy, both son of Shailendranath Roy. So they are the full-blooded brothers. My lord may kindly come to the next page. Clause 1, that the partner shall be entitled to draw salary as below. Vidyut Roy, Biman Roy, rupees 4,000 per month. That the partner shall be entitled to draw interest simple on capital at the rate of 12% per annum. So on these terms and conditions, a partnership agreement was entered into for the purpose of running Roy Auto Center. That name your lordship will get at page 17. Last but one line. Roy Auto Center.
Yes.
Now my lord kindly comes to page 19. Biman Roy died, that the husband of the private respondent died in the year 27th of June 2004.
Yes.
Yes. My lord may kindly turns to the next page, page 20.
Yes.
A fresh deed of partnership was entered into by Vidyut Roy being the writ petitioner and the wife of the private respondent. But that is not eligible. Legible copy, my lord. I have legible copy. I will give it to lordship, my lord. My lord, kindly come to page 28 once. That is the relevant document.
Page
28. Deed of dissolution in respect of the deed. That was of 2005. Vidyut Roy, son of Shailendranath Roy, being one of the partner, and Tika Roy. This is a dissolution of partnership that was being entered into in connection to Roy Auto Center, which was being run by both the private respondent and the petitioner. If my lord may kindly turns to page 30. The relevant portion, these are the relevant portion. The party of the second part, internal page 3. Geeta Roy intend to retire from the said partnership concern due to non-interest in the said partnership business and to avoid mental strain as a widow woman having child daughter of about 7 years, for which the second part, Geeta Roy, have resigned from the said partnership business on and from first day of April 2005. Whereas the party of the second part, retiring part, have received back her share capital on 31st March 2005 from the said partnership business and again reinvested the same in the same said business concern as a loan, which will carry only 8% on loan till repayment. Thirdly, whereas the party of the first part will continue the business as sole proprietorship. I become the absolute owner. Sole proprietorship concern in the same name and same trade name. The new trade name may be included or new trade name may be included by the proprietor Vidyut Roy, and the party of the first part is the sole proprietor of Roy Auto Center on and from 1st April 2005. And whereas the party of the second part, retiring part, shall have no right, title or interest claim in future in the said business and had no legal heir, successor or representative shall have no right, title and interest over the said business. So this was the dissolution of partnership was made between the private respondent and the writ petitioner, whereby the private respondent has withdrawn entire her money with only stipulation that it has been reinvested to get the interest at the rate of 8% per month, 8% interest. But on the basis of this dissolution of partnership, in page number 30, if my lord may kindly comes to, my trade license was issued in the name of the writ petitioner. Since 2006-7,
page
38. This is a certificate of enlistment, is hereby granted under section 119 of the West Bengal Municipal Act of 1993 against application to Roy Auto Trade Center proprietor. My lord may kindly takes note of that. The other partner director has been deleted. Page 38. Is absolutely written as proprietor Vidyut Roy. Address has been given and the purpose of the trade is sales of battery, lubricant oil, electrical and tube repairing. But so from 2000, firm was dissolved in 2005. 2006-7 up to 2017 and 18, there was no dispute and my trade license was issued in the name of the Vidyut Roy, being the writ petitioner before lordship, as the absolute owner, be the proprietor of the said firm. Now in the year 2017, I made an application for renewal of the same. That was sought to be declined by the Vidhannagar municipality on the ground that one Geeta Roy, being the private respondent, has put an objection for renewal of the same in my favor. My lord may kindly see my application for renewal, which your lordship will get at page 52, 51 and 52. 51 is a Bengali document, 52 is a document which has been written in English. Of 14th of November to 2019, I Shri Vidyut Roy, proprietor, my lord has got it. I Shri Vidyut Roy, proprietor of Messrs. Roy Auto Center BE, such and such, do hereby state that I have applied many days ago for renewal of my trade license for the above said property. In this connection, I regret to inform that since 1.5 years past, till date I am not getting my renewed trade license from your end, and I am also astonished to that how my trade license was not renewed from your end. Again, I am submitting my relevant documents for your kind perusal and doing needful. And I hope that you will now renew my trade license on the basis of the above submitted documents. Rent receipts I have given, previous applications I have given, copy of the trade license of 2017-18, so the professional tax, dissolution of the copy of the deed, that dissolution of partnership deed I have also annexed. So these are the relevant documents which I have produced before the Vidhannagar Municipal Corporation, on the basis of which the 2 letters were sent to me as well as to the private respondent, being the wife of the brother. My lord may kindly comes to page 87 and 90. Page 87 is the letter that has been given by the municipal corporation law officer to me, Vidyut Roy, in the year 2021, which was the subject matter of the earlier writ petition. With the reference, may I place it? With reference to the above subject, I am directed to inform you that you had sent a letter for renewal of the trade license of Messrs. Roy Auto Center As per available, you submitted documents. It has found that you had entered into an agreement with Mrs. Geeta Roy after demise of your husband for joining as partner in the said firm. On the contrary, you had entered another agreement with Mrs. Geeta Roy for dissolution of partnership formed by the virtue of the retirement. In the said deed of retirement, you had mentioned the word Srimati Geeta Roy intends to retire from the firm, and you also stated that your agreement that your partnership firm is at will. But there is no such stipulation in my dissolution partnership firm that it is a partnership at will. I have to place before Lordship, even at the cost of repetition, I can place other proportions. In this respect, in terms of Section 32 of the Partnership Act 1932, you have to produce 3 months notice in writing of retirement from the partnership of Geeta Roy. You have to produce the copies of all related deeds registered with the appropriate authority and to produce copy of the registration certificate of your partnership firm. But pausing here for a moment, in my application in the year 2021, I have disclosed all my documents, my rent receipt, my previous trade license, that is certificate of enlistment that stood in my name, and all the documents that are relevant for the purpose of renewal of the trade license. Now, and at the same time, on the same day of 22nd November 2021, a letter was also sent to the private respondent, which your Lordship will get at page 90. So on same day, 2 letters by the Bidhannagar municipality to the writ petitioner, who was the private respondent in the earlier writ petition, and the private respondent before your Lordship, who was the writ petitioner in the earlier writ petition. Your letter dated, my lord got it.
Yes, yes.
Your letter dated, it is referred to the private respondent Geeta Roy, wife of late Biman Roy. Subject, your letter dated 1st of June 2018, docket number such and such. With reference to the above subject, I am directed to inform you that you have sent a letter regarding objection to grant trade license in favor of Vidyut Rai. But it is evident from the available official record that after death of your husband, you had entered into an agreement with Vidyut Rai to be a partner into partnership firm, namely Messrs. Roy Auto Center. On 4th of April 2005, you have entered into another agreement with Vidyut Rai to dissolve the said firm by way of retirement. Now you have to confirm that you have received back your share capital at the time of retirement, and to confirm that you have reinvested your share in the same business as a loan of 8% interest. You are therefore requested to produce all the relevant documents in support of the above mentioned contention within 7 days from the date of receipt of this letter. But so far as this portion is concerned, now that you have to confirm, but that is already stipulated in the in my dissolution of partnership firm, and that has been produced before the concerned authority. But on the basis of this, a writ petition was taken out by the private respondent before Lordship as a writ petitioner, which your Lordship will get at page 94.
Yes.
Page 94.
Yes.
The petitioner happens to be the widow of one Biman Roy, who expired on 27 June 2004. When the husband of the petitioner was alive, he, along with the brother, being the respondent number 8 here, was running a business under the name and style Messrs. Auto Roy Center, as per the deed of partnership executed between the two brothers. After the death of Biman Roy, the private respondent claims that the partnership stood dissolved, and the widow, that is the petitioner who had 50% share capital of the business, reinvested the same with the business as loan, which earns 8% interest. The learned advocate appearing on behalf of the petitioner alleges that her client never signed any document with regard to the dissolution of partnership business. Now he comes and denies the same, that I have never executed any dissolution of partnership. The Bidhannagar Municipal Corporation, after the year 2004, did not renew the trade license for a considerable period of time. The same was again renewed in the year 2018. But that is wrong, my lord. From 2006-7 up to 2017-18, that was been renewed. I have annexed the documents, but has been stopped once again in view of the objection raised by the petitioner herein. The municipality directed both the parties to produce document in support of their claim by letter dated 22nd September 2021. The municipality submits that the petitioner has replied to the letter, but the private respondent has not yet given any reply to the same. The petitioner has raised objection regarding the renewal of the trade license in favor of the private respondent by filing representation dated 5th of October 2021. The petitioner alleged that the same has not been taken up for consideration till date. It appears from the submission made on behalf of the parties and the documents filed before this court, there are several issues between the petitioner as well as the private respondent. The objection filed by the petitioner highlighted that the said issues is pending consideration before the Bidhannagar Municipal Corporation. In view of the above, the instant petition is disposed of by directing the respondent number 3 to consider the representation that has been filed by the petitioner on 5th of October 2021, strictly in accordance with law, after giving reasonable opportunity of hearing to the petitioner as well as the private respondent within a period of 3 months from the date of communication of this order, and to pass a reasoned order and to communicate the same to the parties immediately thereafter. The Commissioner of Bidhannagar Municipal Corporation, respond number 3, herein will not require to enter into any private dispute between the parties. The petitioner is directed to forward the copy of the document relied upon by her in support of the objection raised by her on 5th October 2021 in the aforesaid to the aforesaid respondent at the time of communication of this order. The supplementary affidavit filed on behalf of the petitioner and the report filed on behalf of the Bidhannagar Municipal Corporation in court today is taken on record. The petitioner at liberty to rely upon respective document at the time of hearing. But on the basis of this, two things appears that the Bidhannagar Municipal Corporation has been restrained not to enter into private dispute. The disputes concentrates whether I am entitled to get the renewal of the certificate of enlistment, that the trade license, which stood in my name and has been renewed from time to time from 2006-7 up to 2017-18. From 2017-18, that is 18-19 subsequent year, my renewal was not being made on the basis of an objection being raised by the private respondent. Now, my lord, may kindly comes to the order that has been passed on the basis of the order passed by the coordinate bench. My lord, the submissions have been recorded. My lord, will kindly comes to the page 98.
Yes.
Other portions are relating to the submission made by the respective parties before them. May I read from the second paragraph? On the other hand, learned advocate for the private respondent submitted that his business is a sole proprietorship after resolution of partnership agreement with the petitioner. The learned advocate for the private respondent stated that the said business has been running smoothly and after getting certificate of enlistment from the Bidhannagar municipality. The learned advocate for the private respondent also stated that the renewal of certificate of enlistment was not done after 2017-18. Several applications for renewal was filed afterwards but not considered from the end of the corporation. Learned advocate for the private respondent strongly denies the claim of the petitioner. The learned advocate for the private respondent could only produce the certificate of enlistment in respect of the year 2004-8, besides that of 2017-18. In the intergeneral period, I have annexed the documents. It is pertinent to mention that here under clause 11 of the deed of partnership amended, the private respondent failed to produce 3 months notice in writing of the retiring partner from the partnership of the petitioner. The private respondent failed to adduce any evidence against the notice issued from this corporation by memo number such and such dated 22nd September 2021 it would be. In view of the above, it has been found that the private respondent has not only violated the provision of the section 32 of the Indian Partnership Act, but also terms and conditions of the deed of partnership amended with the petitioner. The learned advocate of the private respondent also failed to produce any scrap of paper regarding rent agreement with the original lessee or owner of the plot number such and such. In view of the above, the undersigned has found no cogent reason to issue the certificate of enlistment in respect of Roy Auto Center from the end of this corporation. My lord, I will show to your lordship, my lord, so far as the documents that I could not produce any scrap of paper regarding the rent agreement of the original lessee. My lord, from page 53 to 83, all the rent receipt I have enclosed up to date. And there also, if my lord may kindly takes up any one of the in between 52 to 83, I will place your lordship the first document, 52, at page 53. This is the rent receipt issued by the owner, Shukendu Bikash Pal. When I received from Vidyut Rai, who is the petitioner before lordship, amount has been given, the rent for the shop has been mentioned, and the premises number. Premises number, it tallies with the order passed by the person concerned, but that is the respondent number 3. And my lord, by the impugned order, the respondent authorities wants to invoke the provision of section 32 of the Partnership Act to deny my renewal, although the provision of section 32 cannot be attracted in view of the specific document that I have annexed with the writ petition, that the dissolution of partnership. The dissolution of partnership has been made inter se between the parties. Parties have agreed to reinvest it in lieu of 8% interest. Parties have also agreed that in succession, in the line of succession, I will never claim any right over the business that has been run by the Vidyut Rai. And pursuant to that, from 2006 up to 2017-18, there was no dispute. Had there been any dispute, under Article 5 of the Limitation Act, my lord, 3 years was the period of limitation. whatever you have to do within a period of 3 years of the limitation, you are to required to be raise an agitation before the court of competent jurisdiction under section 9 of the Code of Civil Procedure. If you have any grievances to say that you have not received back the amount that has been invested, you have not received the interest that you are that is due and payable, that is under Article 5 of the Limitation Act, 3 years limitation. Nothing and no civil suit had been instituted. From 2006 to 2017, continuously my certificate of enlistment has been issued. Tenancy receipt also stands in my name from page number.
Are you paying the 8% interest?
Yes, there is no denial to that effect. This is not the case made out also.
That's all right. I'm asking you.
Yes.
You can file an affidavit to that effect.
Yes.
At the same time, I am
Just a
inviting.
minute. You can file an affidavit to that effect.
Yes.
That she has been regularly getting the.
Because up to 2017, I can show. After 2017-18, I have not been running business because certificate and enlistment has been not been renewed at the instance of the private respondent who has written objection.
Prior to that, you were
Yes.
making the payment.
Yes.
In spite of no license, he is running business. My lord, the paper date is there, my lord, newspaper date, and at the same
That
time.
is for the corporation. Yes. Anything else?
No, my lord. Only one thing I would like to show the Limitation Act. Only I will be showing to the Article 5 of the Limitation Act once.
For what purpose?
Only one that the 3 years limitation is there. If you have
For what?
That if you want to raise any objection as to the payment or non-payment out of the partnership firm, then the stipulation is 3 years. Within 3 years, you have to agitate before a court of competent jurisdiction, that is under section 9.
For recovery, you're talking.
There is no civil dispute to that effect. Only an objection has been sought to be raised before the municipal commissioner that you do not renew my license. And from 2017-18, enlistment has not been renewed in my name. And I am suffering. Private respondent filed a writ petition, did not obtain any order of injunction or restraint order. Court directed you consider, but don't go into the civil dispute.
Yes.
These are my humble submissions.
My lord, one aspect, my lord, lordship was kind enough to clear, my lord, 8% interest issue, and the other is, my lord, dissolution, my lord, the document of dissolution, let it be sent to the handwriting expert, whether my signature is appearing over there or not. If not, my lord.
You can take your rights, file a criminal case. What have you done?
My lord, we have done. Lord, we wrote letter address.
Your dissolution is 2005. When did you write?
My lord, what happened?
When you started looking.
But I am a widow. I am a widow for a considerable period of time. I am at the impression that, my lord, everything will be settled. At a point of time when I am not getting any money to run my business, I went there and to sit and, my lord, the claim 50% interest. He was expelled me from that particular business. My lord, misbehaved with me. Immediately, I wrote a letter addressed to the police authority and thereafter the municipal authority. That being the situation. My lord, the first round of litigation, I am showing, lordship, kindly come to my lord. Here, my lord, the very specific case of mine was page 95. The learned advocate appearing on behalf of the petitioner alleged that her client never signed any document with regard to the dissolution of the partnership business. My lord, that is my.
When did you, Mr. Chakravarti, when did you approach the police authority?
My lord, the police authority. My lord, I have approached police authority, my lord. I'm just showing, my lord. My lord, this letter I am written on 8/5/2018.
2018.
Yes.
When was the deed dissolved?
My lord, I'm showing, my lord. The document actually, page 28, my lord. My lord, he is claiming it is dissolved, but actually I am.
Whatever it is.
My lord, the date he is showing, my lord.
Mr.
That is,
Chakravarti.
yes, my lord, 2005.
How long? 13 years. It took you 13 years to write to the police.
So, my lord, the thing is this. My lord, document has been forged. Fraud has been discovered. Subsequently.
Fraud discovered after 13 years.
Yes, my lord. As soon as it is discovered.
For not getting your 8%, you would have done it much before.
No, my lord.
Wise lawyers, when they come.
Not the question of 8%, 50%. My lord, the business initial, my lord, 50%. My lord, he was not paying after the death of my husband. He's not paying. My lord, the joint family, I did not raise my voice at that point of time because, my lord, I am alone with my daughter, minor daughter. Thereafter, at a point of time, I have gained some courage and went there, thrown me out.
So now your daughter, who was 7 years old, must be how old now?
Now, my lord, at the point of time of 2018, she was.
Doing now?
I'm showing. My lord, 2018, she was 19 years old. 19 years old. At that point of time, I ventured in the shop and thrown me out from the particular shop room. And he is running business in spite of no certificate of enlistment till today. Well, that being the situation, I am not getting any farthing from him. And the same time, this dissolution document is forged document. After
Go to the civil court.
But
agitate everything, file your recovery, after 2018, did you approach the police authorities?
Yes, my
After
lord.
the complaint?
Yes, my lord, the
Where is
complaint is
the-
there. FIR has been lodged by the police authority.
FIR lodged?
Yes, my lord,
Where
the
is-
process is going on, that being the situation. Now, my lord, I have moved this application before this honorable court. Honorable court directed the municipal authority to look into the whole issue. And they come to the conclusion the license should not be granted in favor of them. After that, my lord, my learned friend has approached this honorable court and it is pending. Though it is pending, though there is no certificate of enlistment, yet he is running his business merrily, my lord. That being the situation. And I am not getting any further. It is a joint business. I am showing, my lord, all the document and the document which I have handed over before the municipal authority, my lord, for the reason based on to my learned friend, did not enclose with it. I may be allowed to file my lord, the short affidavit in a few time. Lordship will find, my lord, this is a family problem, as a result of which I have registered myself not to raise the issue outside. But at a point of time, when the my lord, level of tolerance when gone, my lord, I had to do all these things. And after all, municipality, my lord, finally, and the police authority took my FIR and my lord, they have started investigation. Now, my lord, everything, lordship, that if this honorable court kindly permit me, I can show some other papers also.
I am only concerned about the certificate of enlistment
Lordship.
and the order which has been passed.
Lords by the municipal authority. Deeply.
Nothing more.
Deeply obliged, my lord.
I'm not looking into your private
Other paper,
dispute,
deeply
whether
obliged.
you have been removed from the business, not removed from the business, dissolution is forged,
Deeply
not
obliged.
forged,
Deeply obliged.
is not something which I'm.
So, my lord, document which they have placed
I'm
before the
only
municipal.
looking into the order of Justice Sinha.
Yes, my lord.
That whether the compliance has been done
Lordship.
or not, an order has been passed
Lordship.
legally or not.
And at the same time, my lord, whether that particular document, which my learned friend is relying upon heavily, is my lord correct document or wrong document. That is also to be taken into consideration. My signature is not signature. I am ready and willing.
The corporation to
Ready and willing to face my lord handwriting expert.
Not at all. Why have you gone into the private disputes between the parties? Please see page 96, the order of Justice Sinha. The Commissioner Bidhannagar Corporation herein will not require to enter into private disputes in between the parties.
Page 88.
And you see your order which you have passed. You have gone into all private disputes between the parties. Why you have not considered the rent receipts which have been put on record?
Considered at the same time.
You have not considered, sir. Your order does not show so. You have gone into all private disputes.
That case, Millard, need to Millard file Millard a report, Millard, as to why Millard the rent considered Millard without considering the objection which is at page 88.
I'll set it aside, remand it back. Take down.
No, the question of my lord, that 8% interest and others payment, my lord.
Sir.
My lord is required to be, since my lord, she is a widow lady, and my lord, she is not in a position, my lord, to earn his livelihood.
You have your remedies available in law. Take down. The petitioner, comma, in the present writ petition, comma, is aggrieved by the impugned order dated 26/11/2022, passed by the Commissioner of the respondent corporation, comma, whereby it was decided, whereby a decision has been taken not to renew or issue the certificate of enlistment in respect of the business operated under the name and style bracket mein kar dena of inverted commas Roy Auto Center, MS Roy Auto Center, full stop. By the same order, comma, the petitioner was directed to seize all forms of commercial business, all sorts of commercial activity under the said business name at the premise situated at BE01, Salt Lake City, Calcutta. Full stop. The petitioner was initially operating the said business as a partnership firm along with his brother from the aforementioned tenanted premises. Full stop. Upon the demise of his brother, comma, the partnership firm was reconstituted and an amended partnership agreement was executed between the petitioner and the private respondent, comma, who is the widow of the deceased partner, bracket my brother. Full stop. Subsequently, on 1/4/2005, comma, the private respondent voluntarily exited from the partnership firm by executing a deed of dissolution. Full stop. Thereafter, comma, the petitioner continued the business as a sole proprietor under the name and style, comma, MS Roy Auto Center, comma, and obtained all necessary statutory approval and licenses, comma, including the certificate of enlistment from the respondent municipality for the said proprietorship concerned, comma, which was regularly renewed until the financial year 2017-18. Until the financial year 2017-18. Full stop. Learned counsel for the petitioner says that he had applied for the renewal of the certificate of enlistment for the subsequent years, comma, the same was not renewed. Full stop. He further submits that upon inquiry, comma, the petitioner came to learn that the private respondent had submitted a written complaint dated 1/7/2000. Page number?
My lord, that is page number 87.
Written complaint dated 22/9/2021, right?
Yes.
No.
It is
That's the letter of
asking him, my lord, to produce, my
There
lord.
is a complaint.
Yes, they have given an objection, I tell you. Lord.
Where is the complaint given by her?
My lord, one complaint, my lord, they did not include, my lord, not enclosed with the writ petition. That
Just
is
give
with
any
us.
complaint. What complaint? Where is the complaint on which they have acted?
License renewed application.
My lord. Page 88 in Bengali.
Page 89.
What is the date?
Yes, my lord, I'm sure.
1/6/2018.
1/6/2018.
2018. Full stop.
Page 88.
1/6/2018, objecting to the renewal of the certificate of enlistment. Full stop. Thereafter, she instituted WPA number 2465 of 2020 before this court, comma, which was disposed of by order dated 18/7/2022 with a direction to the respondent municipality to decide the pending representation of the private respondent. Full stop. This court also clarified that the respondent municipality was not required to adjudicate any private dispute between the not required to enter into to adjudicate any private disputes between the parties. Full stop. Pursuant to the direction of this court, comma, the respondent municipality heard the parties and passed the impugned order dated 26/11/2022, comma, rejecting the petitioner's application for renewal of certificate of enlistment and directing cessation of business activities. Full stop. Learned counsel for the petitioner contends that the scope of the order dated of the impugned order dated 26/11/2022 was confined to the limited issue of examining the administrative aspect of trade license application. Full stop. This court-wide order dated 18/7/2022 in WPA number 8, WPA number 2465 of 2020 strictly precluded the respondent municipality from delving into inter se private dispute between the parties, full stop. However, comma, from the impugned order, however, comma, the impugned order oversteps this mandate and proceeds to make findings concerning the validity of the dissolution of the partnership deed, comma, thereby traveling beyond its jurisdiction, full stop. The learned advocate for the respondent municipality submits that the petitioner had failed to submit rent agreement concerning the tenanted premises, and he has violated certain clauses of the amended partnership deed, full stop. It is therefore contended that the petitioner is not entitled for renewal of the certificate of enlistment, comma, and the direction and the order and the impugned order has been rightly passed, whereby the commissioner has not renewed the certificate of enlistment and has ordered for cessation of business activities, full stop. Learned counsel for the private respondent states that the petitioner has violated, the petitioner had forged the signatures on the deed of dissolution, and that the private respondent had not signed any deed of dissolution, full stop. He further states that the petitioner had been illegally running the said business from the date of demise of her husband and has not adhered to the terms and conditions of the deed of amended partnership deed, full stop. He further states that in terms of the amended partnership deed, the petitioner was supposed to make certain payments to the private respondent, since the private respondent had reinvested her money earned, her money,
share capital,
her share capital into the business as a loan, which was to carry a interest of 8% till repayment.
Well, that is, my lord, in the deed of dissolution, my lord, the recital in the deed of resolution. Our submission, my lord,
deed of dissolution kar dena usko.
yes, sir, that is not our submission.
Deed of dissolution.
Our submission, it is forged.
All right.
Even if assuming,
line छोड़ ही दो, उसको हटा दो, उसको
Lord, assuming for the sake of,
after forged.
but assuming for the sake of argument,
Deed of
8%,
dissolution is
I'm not
forged.
getting that.
Deed of dissolution is forged. You can't claim it.
Lordship.
You can't claim it.
Lordship, at the same time, because I am
You're saying it's forged. You can't claim
it's forged.
You can't
But
claim
it is their contention. If that we show, well, to show some gesture,
all right.
that amount is required to be paid.
All right. Anything else?
But only one thing, page 96, Honorable Court on the previous round of litigation directed the municipal authority to adjudicate my lord, the representation dated 5th October 2021. Page 96 at the top.
Learned counsel for the private respondent states that the coordinate bench of this court in WPA number 2465/2022, while its order dated 18/7/2022 had directed the corporation to decide petitioner's representation, which has been duly considered by the commissioner of Vidhannagar Corporation, and that the impugned order which has been passed is in compliance of the said.
Our submission is not considered. My lord, it was, my lord, the order was passed finally, but 21st May.
I heard what I said. It's in your favor only.
Lordship,
Sir.
lordship.
Have you heard what I said?
Lordship.
Mr. Chakravarti, the
Lordship,
problem
my
is you
submission.
don't hear.
Lordship.
I have recorded the submission in your favor
Lordship,
only,
lordship,
that your representation
Lordship.
was heard and an order has been rightly passed.
lordship,
This is what your contention is.
lordship, my lord. Lordship.
Mr. Chakravarti, you don't hear.
Lordship, my lord.
क्या लिखा है आप पढ़ के बताओ उनको.
Lordship.
For the private respondent states that the coordinate breach of this court is WPA 2465 of the order dated 18/7/2022 that directed the corporation to decide that we give the contract by the corporation and that the order has been passed is in compliance of this.
That's what you want, Mr. Chakravarti?
Lordship.
Did you hear it?
This time.
It is in compliance
Lordship.
of the direction.
Lordship.
This court has heard the argument advanced by the counsel for the parties and has perused the materials on record. Full stop. It is not in dispute that the petitioner had been granted the certificate of enlistment for the proprietorship concerned from the year 2005-6, which constituted to be renewed until, which continued to be renewed until 2017-18, full stop. The objection to further renewal emanates from the complaint lodged by the private respondent, who disputes the validity of the partnership dissolution as the same partnership dissolution, full stop. A bare reading of the impugned order dated 26/11/2022 reveals that the respondent municipality exceeded its jurisdiction by examining the terms of the amended partnership deed and rendering a finding on its alleged violation, full stop. These issues fall squarely within the realm of private dispute and within the realm of civil dispute between private parties and are not within the competence of a municipal authority to adjudicate upon, particularly when such adjudication stands expressly prohibited by the court's earlier order dated 18/7/2022 in WPA number 2465 of 2020. The issues concerning the validity of the deed of dissolution, the issuance of the certificate of enlistment, the issuance of the issuance of proper notice and the execution thereof by the private respondent are disputed question of facts which fall squarely within the domain of competent civil court and cannot be adjudicated upon by the respondent municipality while exercising its administrative functions, full stop. In view of the above, this court is of the considered opinion that the impugned order dated 26/11/2022 is vitiated by an error of jurisdiction and is liable to be set aside, full stop. Accordingly, the impugned order dated 26/11/2022 is hereby set aside and the municipality is hereby set aside. The matter is remanded, full stop, and hereby set aside, full stop, and the matter is remanded back to the Commissioner, Vidhannagar Municipal Corporation, for fresh adjudication on the issue of renewal of petitioner's certificate of enlistment strictly in accordance with the directions contained in WPA number 2465 of 2020, wide order dated uh, uh, strictly in accordance with the order dated 18/7/2022 in WPA number 24665 of 2020, without entering into the issue of private dispute between the parties, inter se private dispute between the parties. With the above direction, the present writ petition is disposed of.
And the opportunity of hearing must be given by the commissioner to both the parties.
वहाँ पे एक line लिख देना. The commissioner is directed to give a fresh hearing to both the parties and pass a reasoned order. Yeah, वो direction है ना, in terms of the order dated so and so, to pass a reasoned order after affording an opportunity of personal hearing to both the parties within a period of within a period of 6 weeks. Earlier it was 3 months. The direction was 3 months, so let it be 6 weeks.
Deep level.
So उसको 8 weeks कर दो, within a period of 8 weeks.
Grateful to you. Much obliged.
May it please the Lordship, my Lord. I am appearing for the petitioner. Very short point, my Lord. I'll be praying for consideration of representations made by us, not considered by the municipal authorities. Briefly, my Lord, I'll indicate what the facts are. The petitioner's father, Parimal Biswas, my Lord, left for heavenly abode, made a will. The will is probated. I'll indicate the will and the probate. That's not in dispute, my Lord. In terms of the probate, my Lord, there are consequential actions which would be taken by the KMC. They have failed to take that. We have written letters. Those have not been considered. That's the premise of the case, my Lord. My prayer is that those representations be considered by them within a stipulated time frame and be disposed of, my Lord. I'll indicate what the facts are. But kindly take up. My Lord, this is. My Lord, may I quickly indicate the probate is at page 15. Can you take up page 15 once? Page 15, my Lord. I suppose my learned friend is indicating that if the representation is sent to them afresh, they'll consider it, and that's the end of the story. So if that's the case, my Lord, I'll not indicate any further.
Cut down the long story.
So I'll only indicate that I shouldn't falter, my Lord, in indicating the correct facts. I'll only indicate the page numbers. The probate is at page 15 of the will, which is, my Lord, 20th of May 2003. My Lord, you will find that will at page 17 onwards. It's annexed to the probate. In the will, my Lord, which starts from page 17, only one paragraph I'll refer to. Your Lordship will kindly take up page 19, the last paragraph. Dr. Shriman Ashish Bishas, as the petitioner before your Lordship, shall get ownership right of the first story ground floor of this house, subject to the condition that his younger brother, Shambhu Bishwas, shall get half share in the garage room measuring. The measurements are given towards the road ground floor, will be entitled to use half the share of his requirements. Shriman Ashish Bishas, the second paragraph, Lord, at page 20, shall get the entire second story, first floor, shall be entitled to enjoy the same down his heirs in succession. That is to say, Ashish Bishas shall get the ground floor and half share of the garage. And then, my Lord, Shambhu Bishas, the share is given third story. And the daughter, my Lord, the next paragraph, Gauri Rani Chaudhary, will have the third floor and shall enjoy the same. Kindly take up one part, my Lord, page 21. This is the third paragraph. Each of the said 3 persons shall be entitled to effect mutation separately. This is the third paragraph, my Lord. With regard to the respective shares from the Calcutta Municipal Corporation. This is the premise, my Lord. If the corporation does not admit the same, then my 2 sons and daughters shall pay the tax in equal shares. Now, with this, the probate is done. That, my Lord, is at page 15. The representations I'll indicate, and why the representations is, my Lord, that we paid tax to the tune of 10,85,000. No apportionment. This is on 14th October 2022. A fresh, my Lord, balance is shown of 10,85,000 again. No reason why This is suddenly increased to 42 lakhs without any basis. We have made those pleadings. And from the website, we find it should be 27 lakhs without any reason why the inflammation is. These are at page 48. At page 35 first. The payment I'll show from 33, my lord. I'll take a page 33. After making the payment, your lordship will find total balance is 10 lakh 85 at the bottom left-hand corner. The increase is at page 35. Your lordship will find at page 36 and 37. It continues, my lord, till page 42. Without any basis, that's what we say, because 42 lakhs suddenly it couldn't have been. And there, my lord, thereafter from the website, that's at page 44, your lordship will find the figure in the second paragraph, 27 lakh 38,109. We make representations thereafter at page 45, dated 22nd of December 2022, not responded to, followed by another representation, which is, my lord, at page 48, 5th of January 2023, again not responded to. In this premise, my lord, our prayers, where, my lord, we have stated that the representations be considered. Lord, will kindly take up the prayers. It starts from page 11. Because we are challenging the apportionment, my lord. Prayer C. And I understand my learned friend is conceding to this. But kindly make it time bound, my lord, so that we can come back once, my lord, if they take a decision which, my lord, is according to us not proper in law. Because section 183 is what guides this of the KMC Act, my lord.
Take down
2 and 3.
You'll decide the representation, Mr. Makan.
44, in fact, there was a consideration. Your lordship sees page 44. This is my letter to the person concerned, Ashish Bishar. This figure was arrived at after apportionment.
That's
Now, what he is disputing is the apportioned amount probably doesn't fit to his thinking.
No, it
He
doesn't.
says-
My lord, we have indicated this is inflated tax
Yes,
liability,
that
which is not
of course,
justified.
yes,
And that is why the next letter of 5th of January
that is what I am
2023,
saying, the
which is at
quantum
page
is in
48.
dispute. Apportionment has been done. The apportioned amount is in dispute. Let us consider, let him go, we'll consider.
That we have stated at paragraph 7 at page 49. It's a part of our representation, my lord. 7, 8, and 9. That's why we have called out, my lord, the challenge.
Want to make a fresh representation? That also you are welcome. If you want to.
Let them consider this. And kindly, my lord, grant us that liberty that if we want to supplement this, we'll do that.
No, do it before.
No, supplement, I'm not granting you any liberty.
Kindly don't. Look, this will suffice. But this is what encapsulates everything. They have to give us a hearing, my lord, and then let them take a decision. In that hearing, my lord, if it is required, my lord,
Petitioner, by way of the present writ petition, seeks a direction upon the respondent corporation to ensure the proper apportionment of municipal tax in respect of petitioner's demarcated portion, comprising the entire ground floor, first floor, and half of the garage at premises number 4A, Igdalia Place, PS Gariahat, Calcutta, full stop. The petitioner further prays for the supply of a true and correct statement of facts relating to the said property, along with full and detailed particulars thereof. Full stop. It is the case of the petitioner that petitioner's deceased father, late Parimal Biswas, was the absolute owner of G+4 storied building situated at the above mentioned premise. As per his last will, the petitioner is the absolute owner of the entire ground floor, first floor, half of the garage, petitioner's sister is the absolute owner of the third floor, and petitioner's brother is the absolute owner of the second and fourth floor, full stop. The said will has been probated and each of the legal heirs are in possession and enjoyment of their respective portions, full stop. It is the grievance of the petitioner, comma, that the respondent municipality has raised inflated property tax bill on the petitioner without any apportionment and hence the said bills are unjustified and illegal. Full stop. The petitioner had submitted representations dated 22/12/2022 and 5/1/2023, however, no response has been given to the said representations by the respondent corporation. Full stop. In view thereof, I'll just learned counsel for the respondent corporation submits that they are ready and willing to decide petitioner's representation dated
The
5/1/2023. Full stop. Learned counsel for the petitioner states that he shall be satisfied if the same is decided within a time-bound manner. Full stop. In view of the statement made by the counsel for the parties, this court directs respondent number. Who's the assessor and collector?
I'll tell your lordship.
Assessor and collector.
Respondent number 4, my lord.
Respondent number. This court directs respondent number 4 to decide petitioner's representation dated 5/1/2023 within a period of
4 weeks.
Within a period of 6 weeks from the date of communication of this order, after, strictly in accordance with law, after affording an opportunity of personal hearing to the petitioner, by way of a speaking order, full stop. Needless to state, if the petitioner is aggrieved by the same, challenge the same in accordance with law.
Very deep. Great.
He is at liberty to challenge the same in accordance with law.
Deeply.
So with the above direction, the present writ petition is disposed of.
Deeply.
Much.
Yes, Mr. Satadhar.
Mention at this time. There is a matter, my lord, concerning one of the oldest Chinese inhabitants of Calcutta, my lord. There is an apparent threat of demolition, my lord. We are only requesting for listing, my lord, because my name has been removed from the list of assessees of the municipal corporation without any prior notice. I have a 99-year lease over the property.
But how does it lead to, and where is the other side?
My lord, we are mentioning, my lord, we'll serve them and for tomorrow, my lord, tomorrow.
Without serving the other side, mentioning is not allowed, Mr. Satadharu.
My lord, we'll serve and then make an effort.
That's
tomorrow.
not the practice.
I apologize. We'll serve and my lord, try tomorrow, my lord.
Mention it, you serve them, mention it tomorrow.
Yes, my lord, we will do that. Most grateful.
Rest of the matters tomorrow. Which one was yours, Mr. Ghosh? 11. Today you were not here. Where were you? Other court.